All right, Mr. Dreiser, you may cross-examine. Do you need to move that for your? Okay. All right, you may proceed.
Thank you, Your Honor. Good morning, Detective. How are you?
Good morning, sir.
Thanks for being here. You all settled in?
Yes, sir.
Okay. Detective, you would agree that this is by far the biggest case of your career?
Yes, sir.
Okay. This case is not only a big case because of the media attention, it was a long and exhaustive investigation, correct?
Yes, sir.
And I want to ask you a few questions about both. From a media perspective, do you agree that this case did in fact get major media attention?
Yes, sir.
Not only during the course of your investigation early on, there were news reports, correct?
Yes, sir.
Okay. And there were, when people got arrested, the court was recorded, correct?
That's correct.
So not only from what the media kept reporting as you guys got updates in the case, when people got arrested, whatever happened in court was made publicly available, right?
As far as I know.
Sure. Anyone that wanted to watch it on numerous live streams could know exactly what was happening if they so choose to do that, correct?
I mean, as far as I know, I wasn't present for everything, but as far as I know, it was, yes.
Right. And you also know that as your investigation went on, you would sometimes purposely release information, correct?
There were times during the investigation where a decision was made to use an arrest as a tactic, yes.
And there were some times where tactically you did not release information so that the public could not know, correct?
Not necessarily. I'm not sure what you're referring to.
Okay. You sometimes purposefully released information, like the blue truck, and we'll get to that later in my cross-examination. But there were also pieces of information that only law enforcement knew about the investigation that was not publicly available, especially early on in the case, correct?
That's correct.
Okay. Maybe I just didn't ask you a good question. We both agree to that fact, right?
Yes.
Okay. And as part of the exhaustive nature of this investigation, it was 11 months before any arrest was made for this particular case, right?
Yes.
So there's a lot for me to ask you about today. You agree with that, right?
Yes.
Okay. And you were the lead detective in this case?
Yes.
Detective Lamont helped you?
He was my co-lead.
Okay. And as you guys got developments, you never let up, right? You just kept pushing and trying to get more and more evidence to make your case, correct?
I would kind of reject that premise. You follow up on leads, and you either develop new leads and you follow those leads, or information kind of dies out and that lead dies out.
But over the course of 11 months, you were looking for leads. You were looking for new information.
Yes.
I mean, that's what that whole table up there is shell casings from the night of, tires that you later collected, boots that you later collected. I mean, that was what you were doing, right?
That's correct.
Okay. Now, and you've answered most of these questions, but personally, you are only part-time at the Sheriff's Office or the Jax Beach Sheriff's Office now?
Yes.
Okay. You're only putting in about 10 hours a week?
Depends on what's going on. It can vary.
And you are now a financial planner in your own private business, unrelated to law enforcement?
That's correct.
Okay. And because of what you described as some of the background that you have working at banks, they sort of deem you the finance guy at Jax Beach's Sheriff's Office?
I handled most of the financial investigations. That's correct.
Okay. But you agree you don't have any degrees in banking?
I don't think there is a degree in banking per se, but no, I do not have a degree in finance.
Or a business degree of any kind?
No.
Okay. You don't have any degrees in taxation?
I hold a license in taxation, but I don't have a degree now.
You're not a CPA?
I'm not a CPA.
Okay. And in terms of being a financial planner, there are certified financial planners or CFPs. You're not one of those?
I'm not a CFP. I am an enrolled agent, which is a designation that the Treasury issues.
Okay. But nonetheless, without ever having worked a homicide before, because you were on call, this became your case. Is that right?
That's correct.
Okay. I want to get some background, some context, because I think some names have been thrown out in this case. Do you remember saying the name Jeremy Ordway yesterday?
Yes, sir.
Jeremy Ordway became the tenant of Potomac on...
Around the beginning of the year.
Well, it was after January, moving into February, right? And I'll show you the lease later, but I'm trying to give them some context of who Jeremy Ordway is. That was the new tenant of Potomac between January and February of 2022, right?
That's correct.
Okay. And then, of course, we've all heard the name Henry Tenon, and I think you said on your direct examination that Henry Tenon was still living at Potomac after the homicide. Detective Burrell yesterday told us he didn't think he was living there. I'll let the jury make the decision. But my question to you is, Henry Tenon and Jeremy Ordway have a relationship, correct?
Yes, sir.
Okay. It's not like, you know, in a typical situation, you move into a new place, the old tenant can't stay there unless, in fact, you would agree that they are friends.
I would say they're friends.
Right. And it's because Jeremy and Henry Tenon's father, before he passed, they had a relationship, correct?
Yes, sir.
Okay. So in some ways, they were family friends.
It's fair.
They lived on the same street at Potomac.
Correct.
Right. So when Henry Tenon is seen over at Potomac, and I'm going to show you, and we're going to talk a whole lot about it this morning and afternoon, about why those two people are together, it's because they, in fact, are friends, and it's not unusual that Henry Tenon would be at Potomac, correct?
That's correct.
Okay. I'm going to try to go chronologically, but yesterday the jury was left after seeing an interview of Mario Fernandez, and I'm sure you remember that, correct?
Yes, sir.
All right. And I want to ask you a lot of questions about what they heard and what they didn't hear in that interview. Is that fair?
Okay.
When someone goes in for an interview, let's start with a few basic premises. He came in voluntarily,
Yes, sir.
with no hesitation.
That's correct.
He didn't bring a lawyer with him.
No.
He answered your questions.
Yes, sir.
And during that interview of Mr. Fernandez, as a detective, you're gauging whether he's telling the truth or he's lying, correct?
At that point, I'm making a record of what he's saying. I'm not necessarily gauging whether he's telling the truth or not.
In that moment, you're making a record, but certainly as a good detective, you're going to try to find out, was he telling me the truth or was he telling me lies? You have to have done that, right?
Part of what is done when you're doing an interview is you are making a record of what people say, so that later on, if something is said that contradicts that, you have a record of what they said earlier.
That would be a lie.
That's true, yes.
So in a nutshell, I asked you a simple question, which was, you're trying to make a decision after you listen to what they say, you do some detective work, and then you say, was this guy being truthful with me, or was this guy being a liar? That's part of your job, right?
Sometimes, yes.
Yeah. And you're also trying to, and you would agree, people react differently in police interviews, right? There's no right way to react, right?
Correct.
So Mr. Fernandez talked a lot. You would agree with that?
Yes.
Some people could say, well, he talked a lot, so he was nervous. Some people could say, if a person comes in and they don't really expand on their answers, that could be suspicious, right?
Not in itself, no.
Right, because everybody reacts differently to police interviews.
Correct.
So just the way a person acts doesn't tell you one thing or another about their involvement in a crime, correct?
No.
Okay. No, meaning yes, you agree.
I agree with you.
Thank you. Okay, so now let's talk about questions that the state didn't ask you yesterday. Mr. Fernandez told you that there was an issue with AB, sorry, Judge, about purple hair. Do you recall that?
Yes, sir.
And how Mr. Bridegan, Jared Bridegan, went bananas. I don't think that was the word he used, but he went apoplectic. He was pissed off about her wanting to dye her hair purple, correct?
According to what Mr. Fernandez said, yes.
That's exactly right. According to what Mr. Fernandez says. We don't know. But as part of your detective work in this case, you went and spoke to Bishop Curry, correct?
Yes, we did.
And he confirmed that Jared did confront him about purple hair, correct?
I don't remember if it was necessarily about the hair color or something else, but yes, he did go and speak with Bishop Curry.
Yeah, and it was about Bishop Curry giving advice to the Gardner family, and he's a bishop.
Your Honor, the state's going to object. This is all hearsay.
Grounds? Okay. Response?
I'll ask it differently.
All right.
You were able to confirm that what Mr. Fernandez told you about the confrontation between Jared Bridegan and Bishop Curry did in fact happen.
I was able to confirm that there was a confrontation between the two of them.
Thank you. And in fact, that Bishop Curry was pretty taken aback by how aggressive Mr. Bridegan was during that confrontation.
I don't remember his specific language that he used. I believe he was surprised by the interaction.
The aggressive nature of the interaction.
I don't remember him saying aggressive or using that type of language. I just remember him being surprised by it.
He wasn't pleased with Mr. Bridegan coming to his house, was he?
No.
Thank you. You heard Mr. Fernandez tell you that the child reported that during that date night, on the night of the homicide, that Mr. Bridegan took a phone call, correct?
Yes.
Mr. Fernandez wasn't there during that date night, right?
That's correct.
There's no way he could have known that, to tell you that, unless someone told him that, correct?
That's correct.
And you were able to confirm that during that date night, on that day, Mr. Bridegan did in fact take a phone call. It lasted about 20 minutes at the beginning of the date night.
Yes.
So again, what Mr. Fernandez told you checked out to add up to something that actually did happen, right?
Yes.
Okay. There was some school issues brought up by Mr. Fernandez. And Mr. Fernandez told you that the way the school perceived Miss Bridegan and Mr. Bridegan and whether they were friendly, you were able to talk to some of the school teachers in this case, correct?
We talked to one school teacher, yes.
Okay. And I'll represent you. They're going to testify in this trial. But they confirmed that the Bridigans weren't really happy with the school situation, correct?
I don't remember the specifics of the interview. I don't remember them talking about that particular aspect of it.
Okay. Would you agree with me that whatever they tell the jury about how the Bridigans perceived their happiness with the school situation would be the truth?
Your Honor, I'm going to object to speculation.
I'm not asking him to speculate what they're going to say. I'm asking him to speculate, accept that whatever they tell the jury is how they felt.
The court will sustain the objection on other grounds, invading the province.
Okay. So, Mr. Fernandez reported to you that Kirsten Bridegan was unhappy with the notification that the school gave out to the public regarding the death of Mr. Bridegan. Do you recall that?
Yes.
You were able to confirm through Mrs. Bridegan that she did in fact contact the school and she was not happy with that.
I don't remember if I confirmed that through her, but it was confirmed.
It was confirmed. So that was also true,
Yes.
correct? Lastly, do you recall one more fact that was confirmed? He told you that Mr. Bridegan's brother had left the church, and there was strife in the Bridegan family about that, right?
I don't know what the particulars were in the strife of the family. I do know that he did, in fact, leave the church.
Right. So let's break that down to what I'm asking you. I'm not asking you about the particulars of the strife. So let me ask a better question. Mr. Fernandez told you in response to issues that were going on that Mr. Bridegan's brother left the church.
Yes, that was a statement that was made by Mr. Fernandez.
And then later you were able to confirm that that was true.
Yes.
So again, as part of the work that you did post the interview, you were able to confirm, for example, he told you the children's therapist was Mercedes McGowan, correct?
Yes.
And that was a big issue that he talked about. You were able to confirm the children's therapist was in fact Mercedes McGowan, correct?
Yes, sir.
And there was issues about whether the Bridigans wanted her going to Mercedes McGowan or whether the Gardner camp wanted her to go to Mercedes McGowan. You confirmed that was a true issue, correct?
Yes, sir.
Okay. So what you're learning from him all sort of panned out, correct?
Everything we've spoken about so far, yes.
And then when someone's giving a police interview, they could just come in, if they wanted to make it seem like they were distancing themselves from a crime. They could say something like, well, there was really no problems between us and the Bridigans, you know, little issue here, a little issue there, but we got along great. And then you would confirm that's not true. Mr. Fernandez didn't do that, did he?
No.
I mean, he told you there were issues, he told you what the issues were, and everything he told you checked out in terms of those issues that he identified, correct?
He was very candid about the issues between them.
Okay. And then, do you recall answering a question yesterday about motive? It's a big issue in this case. The government's alleging that the motive in this case is a child custody issue. You agree with that?
Yes.
Okay, and they asked you, before we even played the interview, at what point in the investigation did you come up with this motive? And you said, well, Mr. Fernandez said that he wanted to do a social investigation so they could get majority time sharing. Do you recall saying that?
Yes.
And that's the snippet of information that you gave the jury before that interview, correct?
Yes, sir.
Okay. But the jury's now heard the entire interview, correct?
Yes, sir.
And it's in evidence, right?
As far as I know.
Okay. But and I don't want to put words in your mouth. I want to use the exact words of what was spoken. So let's see what we can agree on. And any time, if you need to look at the transcript, you let me know, or we can play the video. Okay? Mr. Fernandez told you that there was an issue with the children, AB and LB specifically, and Mercedes McGowan, the therapist, right?
Yes.
And the issue was they thought it was really good for the children, meaning the Gardners, Mario Fernandez and Shanna Gardner, and the Bridigans did not want the children to go to therapy. In a nutshell, that's what he was telling you, correct?
That was the statement made by Mr. Fernandez, yes.
Right. And then, in response, you say, the therapy. Okay? Take my word for you?
Okay.
And then Mr. Fernandez says he wanted it to stop. And he was saying that he never agreed to it and that they had to go and tell the kids, I don't know if he thought that they were in there with the kids. And he goes on to talk about why Mr. Bridegan wanted the therapy to stop. Fair enough?
Yes.
And then you say that's why he wanted it to stop. And then Mr. Fernandez says he wanted it to stop. Then he sent us a thing through his lawyer. We forwarded it to our lawyer. And our lawyer was more or less, is this real? Is this serious? Our lawyer legitimately told us that he ignored it because he didn't think it was serious. And he waited out the time. Then he went back in and got serious and was like, I haven't received a response and blah, 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 blah. We asked our lawyers, hey, can you respond to this? Because this is getting out of hand now, and it's absolutely ridiculous. Fair enough?
Okay.
Then Mr. Fernandez went on to say, our lawyer was prepared to be like, I hope this goes forward so I could just crush him in court. We were hoping that he was going to push it so that we could file a social investigation against him. I'm going to stop there for a second. Mr. Fernandez was saying, we hope that he was going to push it. Push it was the fact that Mr. Bridegan, he was Mr. Bridegan, you agree with that, correct?
Yes.
That Mr. Bridegan was going to push the issue of taking the children out of therapy. That's what Mr. Fernandez is telling you.
I can only say that, yes, that's what the transcript says, yes.
That's all I'm asking you.
Okay.
What he told you. That's what you're basing your response to this jury yesterday was, we believe the motive, in short, was he wanted to push a social investigation and majority time sharing. You got that from that interview, correct?
That is part of a larger context of things.
Sure.
Yes.
But right now, in the interview, this is the part where we're talking about those two things. Social investigation, correct?
Yes.
And we're about to get to the majority time sharing.
Okay.
So to back it up, he's now telling you what the lawyer was going to do if Mr. Bridegan pushed the issue of taking the kids out of therapy, correct? That's where I left off?
I mean, you're reading a small bit of a long interview.
I'm going to read the whole.
I understand, yes, what you're saying, based upon that part of it, yes, that's accurate.
Okay. So then Mr. Fernandez goes on to say, because up to pretty much this point, the primary goal, because it wasn't amicable and because how they're being with the kids, we were more or less fighting for the kids to have a chance and for Shanna to have majority decision making. Okay, I'm going to stop there. That's different than majority time sharing. That's just decision making for health decisions, correct?
I believe that he wanted them to have control over the children. That's how I perceived his statement.
That's how you perceived it. But
Yes.
the words
Your
are.
Honor, I'm objecting to this line of questioning because it's calling for
Let me
speculation.
see your side.
Madam Court Reporter?
You may proceed.
Thank you. I want to make sure we know exactly where we left off, because I want every word to be considered in this paragraph, because this is the part where you learned about the majority time sharing, correct?
Okay.
So I left off exactly with decision making. So the first thing that Mr. Fernandez said after you were discussing the therapy was that it would be better if maybe she got decision making. That's the word that Mr. Fernandez used, correct?
Right.
Okay. And then in the next sentence, Mr. Fernandez says, if she could have more timeshare on her end, if it was 60-40 or whatever, we could bend it just enough, it'd be great because the kids would be better off. If we could push them into the corner of all the interaction with the kids, we need all to be together so they could just suck it. I don't care if they're suffering because they're uncomfortable, okay? And he was obviously not referring to the children being uncomfortable. He was referring to the Bridigans, correct?
Correct.
And this whole concept that you told the jury yesterday for motive was that Miss Gardner, you believed, and Mr. Fernandez wanted majority time sharing is what you said, correct?
That's what the transcript says.
Right. But 60-40, meaning 10% more time sharing, Detective Johns, correct? That's what Mr. Fernandez said, correct?
In the transcript, yes.
Right. So in the transcript, he's saying if we could just bend it slightly, it would be better off for the children, correct?
That's what the transcript says.
And 60-40 is 2 days a month, correct?
Okay.
Nowhere in that transcript does Mr. Fernandez ever say that they were trying to take away Mr. Bridegan's time sharing, correct?
I think if you look at the total context of the interview,
Yeah.
I believe he was saying that they wanted them to have majority control over the children.
By way of 10% more. I mean, a majority is 51%. I mean, you know from your business background, that's what a majority means, correct?
Yes.
So he says 60-40, 10% more is the majority.
Yes.
We're not speculating because you keep saying, well, that's what Mr. Fernandez said. That's exactly what Mr. Fernandez said. If we could just have 60-40, we could bend it just a little bit, the kids would be better off. That's what he said.
That's what the transcript says.
You keep saying that's what the transcript said. Detective Johns, he is the transcript. You are the transcript, Detective Lamont is the transcript, and Mr. Fernandez is the transcript. That's what the transcript is. It's 3 people that were talking in a room, correct?
Yes.
So when I say that's what Mr. Fernandez said, that's what he said, and then it was transcribed, correct?
That's correct.
Okay. And to be very clear for the record, when I keep saying that's what was transcribed, it's from what Mr. Fernandez said in the interview, not the transcript, because they saw the interview in its entirety yesterday, right?
Correct.
Okay. Now, during your investigation, you never took the time to read the family law docket in this case?
It was read by one of my colleagues.
Okay, but you personally, as the lead detective, never read it?
I have since read it.
Since the last time I asked you, and you told me you hadn't read it, you've now gone back and read it?
I have read the docket, yes.
Okay. Did you actually read the pleadings?
No.
Okay, well, I'm going to represent to you that many of them are in evidence, okay? So I'm going to walk you through that, is that right?
Okay.
So let's start with, let me go to my notes. Defense Exhibit 1A. When you say that since the time I asked you last, which was only a few months ago, right?
Yes.
So it had been far after Mr. Fernandez was arrested until the time that you read the docket.
That's correct.
Okay. This is the docket that we're talking about, and this is, for the record, Defense Exhibit 1A. Do you agree with me this is the docket?
Looks to be the same.
Okay. And the docket, as you understand it, means all of the pleadings, all of the motions, all the filings are contained within the St. Johns County Family Law Clerk of Court, right?
Yes.
So everything that was done, the jury now has an opportunity to look through because it's in evidence. Do you agree with that?
As far as I know.
Okay. You're also aware that there was a family group chat that existed between Shanna Gardner, Jared Bridegan, Mario Fernandez, and Kirsten Bridegan.
Yes.
And there were thousands of messages in that family group chat.
There was a lot, and I don't remember the exact number.
And you and your team had an opportunity to look at all of those, correct?
Yes.
And there's nothing that you're aware of in there that had any evidentiary value as to a threat of violence?
That's correct.
Any kind of, let's just not beat around the bush. It was about scheduling for the most part, correct?
But things you would probably expect to find in a family chat.
Yeah. Medical decisions between the children?
Yes.
Pickups and drop-offs?
Yes.
Exchanging medical supplies or school supplies?
Yes.
Okay. And that comprised over years of information that you and your team were able to investigate. And you would agree sometimes there were little snips from one side or the other, right?
Correct.
Okay. But in all of that, there was nothing, as you've already told me today, that you can say, yeah, this went to motive, this went to violence, this went to why we believe Mr. Fernandez is involved in the crime out of the thousands of messages that you read, correct?
That's correct.
Okay. Now I'm going to go back in history and I'm going to show you Defense Exhibit 1B. This is the consent final judgment of dissolution of marriage. Okay? This is, in fact, the initial document that Jared Bridegan and Shanna Gardner agreed to regarding time sharing, or as the state uses, custody in this case. You agree with that?
Yes.
And you know, even with just limited family law knowledge, that a consent final judgment means both parties agreed.
Yes.
They didn't go to court and a judge said, after all this fighting, I give you X, I give you Y. These two parents, for their two children, came to an agreement, and the agreement says, on page 4, page 4. Section 7. No, go down to the parenting plan, sorry. So part of the consent final judgment is also their properties, what they do with their cars, what they do with their houses, correct?
Right.
Okay. And as part of the property, are you aware that Ms. Gardner was ordered to give Jared Bridegan $390,000?
I think it was part of their marital residence, but I don't know the specifics of their divorce.
Right. She got to keep the house. In exchange, she gave him $390,000 in cash.
Right.
Okay. Just want to make sure you're aware of that. Now, where it says time sharing schedule, in section 7, you can go down. It'd be easier if I have the. Okay. See where it says in section B below, this schedule is intended to be a 50-50 time-sharing schedule.
Yes.
Clear as day, they agreed to 50-50 back in 2015 by agreement of the parties.
Yes.
Okay. Now I want to show you what's been put into evidence as Defense Exhibit 1C. This is called a supplemental petition to modify time sharing and support and other issues. Can you see that?
Yes.
So this is now Ms. Gardner going back to the court and saying, I'd like to change what we agreed to, right?
Correct?
Okay. And now, in the supplemental petition that was filed by Ms. Gardner, if you would go to page 3, paragraph 3. This is the right one. May I approach the hard copies? It's just
Yes.
hard on the computer. This day, there are 2. It's the other one. The one that she filed herself. May I approach the witness?
Yes.
Oh, actually, I'm going to...
Is that still the same exhibit?
It is 1C, and I'm going to try not to be so archaic. I'm going to use some technology.
All right.
It takes a second. All right, we got it. All right. Detective, can you see the supplemental petition to modify the parenting responsibilities?
Yes.
Okay, my question was to you. This is Ms. Gardner going in and asking for a change, right?
Correct?
Read for the jury what Ms. Gardner, without the assistance of a lawyer, asked for the judge to do in modifying timeshare.
A more beneficial time sharing schedule for the children has been successfully utilized since June 2016 of 1 week on and 1 week off with a Wednesday date night.
Okay? So she's just asking for a different 50-50 time-sharing schedule, correct?
She's asking for a modification to the time sharing agreement.
You have to agree with me that week on, week off is a 50-50 time-sharing agreement.
Just reading what the document says.
I'm asking you. If you're with your children for 1 week, and then they're with the other side for another week, and then you're with them for 1 week, and you go a whole year or a whole lifetime, wouldn't you agree with me that's an equal time-sharing schedule?
Yes.
Thank you. And in this particular case, and the jury has the ability to look at all this evidence because it's been admitted, it's been marked, and it's in, they can determine what the change was. So without going back, the last one, it was a few days in between, and now she was saying, let's just go a week on and a week off. And you would also agree that she's telling the court that they've already started doing it, and it's been successful since 2016. That's what she says, correct?
Based on the document, yes.
Okay. Wasn't trying to take away any time sharing from Mr. Bridegan.
Not according to this document, no.
Now, let's go to paragraph 5 of the same document, because now we've asked you about what she asked for. Now let's ask why she asked for it. Can you read paragraph 5 to the jury?
The schedule change has been agreed upon mutually because it allows them to have more stability for the majority of the time, as well as looking forward to a midweek visit with the opposite parent. Having the kids rotate homes every few days was too emotionally upsetting because it was too much instability for them to handle.
Okay. Sounds consistent with what she's asking for, correct?
Yes?
Okay. And did you know, because you've read the docket, that that's exactly what they did? That by agreement, without a judge having to get involved, they agreed to week on, week off with a Wednesday date night. Right?
Okay.
Right?
That's what it says, yes.
Yeah. Well, that's what she asked for, and then they actually came to an agreement to do that. right?
Yes.
Now, in 2019, a few years later, Ms. Gardner files another supplemental petition, which has been marked in evidence as defense 1D. Can you see that?
Yes, sir.
Okay. Take as much time as you need to review it, but would you agree with me, after you've had time, that this supplemental petition doesn't seek to modify time sharing in any way, equal time sharing in any way?
Give me just a moment to read it.
Sure. May I approach the witness?
Yes.
I'll just give you a whole hard copy so you can look at the entire thing.
Thank you.
For the next page.
Okay. What was your question? Sorry.
Would you agree with me that nowhere in that document in 2019 does Ms. Gardner seek to take away any time sharing from Mr. Bridegan?
It just discusses how they'll split up more holidays, and then there's a mention about their schools.
I'm going to ask you all about that.
Okay.
But I thought my question was pretty clear, so let me ask again. Do you agree, after reading that entire document, that nowhere in that document does Ms. Gardner seek to change equal time sharing with Mr. Bridegan?
No.
Thank you. What it does do, so I'll give you a chance to tell the jury whatever you want, is it goes to codify or make Wednesday night the official date night, correct?
Correct.
All right. Now I want to pause on just that point, because in this case, there was a crime that occurred on date night. You agree with me on that?
Yes, sir.
This docket, these pleadings that I'm showing you are all publicly available, correct?
Yes, sir.
So the idea that that's some personal detail that only the Bridigans would know and only the Gardner Fernandez residents would know is simply not true. It's public information, correct?
The docket is publicly available to my knowledge.
Sure.
I don't know if there are certain restrictions on documents when they involve minor children or not. I don't know I can't say who would and would not know
I'm not asking.
Well,
We don't know who went on the docket and read it. I'm just saying it's publicly available, correct?
yes,
When I asked you about it at your deposition, you said you hadn't read it. You came in today and said you did read it, correct?
that's correct.
You didn't need to get a login or a password or an account, correct?
I couldn't open the actual exhibits. I could only see the docket because I didn't have a registered account.
Okay, but as a public user, you are able to go through and look at it and do it. You just didn't, correct?
I honestly don't know
Don't
the answer to the question.
You don't know how to answer the question. You don't know the answer, right?
I don't know.
Okay. So Wednesday she asked for Wednesday night to be the official date night. That's what it does ask in that petition, correct?
Correct.
All right. Then it goes on and it has an issue with school, correct?
Correct.
And then Ms. Gardner acknowledges that the communication between Ms. Gardner and the Bridegan camp, it can be frustrating at times, right?
That's correct.
So she says, we'd like for the court to implement OFW. Do you know what OFW is?
The app, the Wizard app?
That's right, Our Family Wizard. And that's an app that parents can use to better and effectively communicate in a family law case, right?
Correct.
And the other interesting part of her asking for OFW is that it also can be court monitored, correct?
As far as my understanding.
Right, so that it keeps people honest. If once it's on OFW, it's recorded, and if the court is so inclined to look, they can. That's one of the tools that OFW offers and why courts utilize it, correct?
As far as my limited understanding, yes.
Sure. And of course, in this case, Ms. Gardner is saying, let's give OFW a try. That's what she's asking for in the supplemental petition.
That's correct.
All right. Then the next issue that Ms. Gardner brings up is now an issue between the new step-parents that are involved. Because in 2019, Mr. Fernandez is now involved with the children, correct?
Yes.
Kirsten Bridegan is now involved with the children, correct?
Yes.
So read for the jury what Mrs. Gardner petitions the court in regards to the parties, new step-parents.
Are you talking about the number 10 on the screen there?
Please read paragraph 10.
The father is currently insisting that the mother's new husband may not exercise overnight time sharing with the minor children when the mother is away. He is additionally creating problems with the mother's new husband being involved on a more general basis with the minor children. However, he insists that his own new wife should be fully involved in the children's lives. The father's new wife is a positive influence in the children's lives, as is the mother's new husband. Both new spouses have strong and positive relationships with the minor children. This paragraph should not be construed as a personal attack on either step-parent.
She went out of her way to make sure that even with what they wrote in that paragraph, that no one would perceive it as a personal attack, right?
That's what it says, yes.
Miss Gardner went out of her way to say that Miss Bridegan is a positive influence in the children's lives, correct?
According to this document, yes.
That's all I'm asking you about, what's in the
Yes.
That's all it says, is that she's a positive influence in their lives, correct?
Yes.
And she's saying that Mr. Fernandez is also a positive influence in their life. That's what the document says, correct?
Yes.
Right? And she's asking for the court to clarify their old parenting agreements that don't address step-parents, correct?
That's correct.
She didn't do this outside of court in a self-help mechanism. She went to the judge, she described what the issue was, and she asked for court intervention, correct?
That's correct.
Without personally attacking anybody, right?
According to the document, that's correct.
And without taking away a single second of time sharing from Mr. Bridegan, correct?
According to the document, yes.
Well, you keep saying according to the document, so let me ask you, what document are you going to tell me exists that's contrary to what I'm asking you? The whole docket's in evidence. Show me the court document that says that she took away time sharing from Mr. Bridegan.
I'm not aware of a document that says that.
Because it doesn't exist, right? That's why I'm walking you through this, to show that the documents that do exist show time and time again that they had an equal time sharing schedule that no one interfered with, correct?
Correct.
It's been alleged in this case that this was one of just the most toxic family law cases. That's why I'm walking you through this. So now I'm going to show you what's been marked and put in defense exhibit later in time as 1E. Can you see that?
Yes.
It's a motion for school determination and request for expedited hearing, meaning school's coming up, we got to figure out what school they're going to, can we get a quick hearing? You agree that's what it says?
Yes.
Okay, now I'm going to show you what's been marked as 1G. I'm sorry, 1F for the record. Consent order regarding school choice. Without going to court, the parties immediately came to an agreement and picked a school. Correct, Detective?
Yes.
By way of agreement, they just said, we can do this on our own. This is what we came up with. That's what the consent order says.
Yes.
Now I'm going to show you what's been marked as Defense Exhibit 1G. This is the mother's motion for declaratory relief. If you want to take a moment to read it, I can give you the hard copy. This is regarding an issue regarding the breathing machine for LB, correct?
That's correct.
Simple issue. They were trying to figure out who should keep the breathing machine, correct?
That's correct.
And the jury's heard somewhat, but LB had a breathing issue and some medical issues where he could only live in certain parts of the country that were near to
Sea level,
right?
Yes, sir.
Okay. Now I'm going to show you Exhibit 1H. Mr. Bridegan responds to the motion, correct?
Yes, sir.
Okay. Now I'm going to that was 1G for the record. Sorry, Your Honor. And now I'm going to show you what's 1H. Again, no court intervention. The parties came to an agreement and a consent order on that exact issue was entered into evidence, was filed, correct?
Correct.
All right. On the family. So to wrap it up, it's all in evidence for the jury to see, but when there were issues leading all the way up to the time of the homicide, they went to court and they agreed, correct? By way of consent.
According to these documents, yes.
Are you aware, has anybody reported to you that there was some nasty trial in this case where witnesses were called and mudslinging occurred that I'm just not asking you about?
No, sir.
May I approach?
Yes.
I'm going to collect a document and drop off a document.
Okay. You may throughout, Mr.
Thank you, Your Honor.
Okay.
That sticker is for the clerk's office. Okay, thanks. Did you get a second to look at it?
Yes, sir.
I keep forgetting because I'm a dinosaur, but there's better technology where everybody can look at it together. I'm showing the witness what's been marked as 1J and entered into evidence. Detective, this is a suggestion of death.
Yes, sir.
This was not filed by Ms. Gardner herself. This was filed by her attorney, correct?
Correct.
And you know that because if you go to the second page, it says respectfully submitted Denry Mason, correct?
Yes.
And you know that was her family law lawyer.
Yes.
And it has two paragraphs. One, that Mr. Bridegan died on February 16, 2022. That's true?
Yes.
And don't you think after reviewing the entire docket, and you may not know this, that that's required, that when a party in a family law case dies with minor children, that the court needs to be made aware? Does that shock you?
No.
Okay. And 2, there is not currently any pending issues before the court and no hearings are scheduled. That was true, correct?
Correct.
Because if you look on the docket sheet, and I'll be glad to show it to you, 1A, the last open pending issue was 4 months prior in October of 2021.
Yes, sir.
Correct?
Yes.
And the case was closed.
Yes.
I'm going to switch gears from the family law case, okay? To give the jury a little bit of background, Mr. Fernandez and Ms. Gardner, they lived in Jack's Beach at the Marsh Inlet address, right?
Yes, sir.
Mr. Fernandez owned a few rental properties in town, correct?
Yes, sir.
One of them was the Potomac address.
That's correct.
And at a certain point in time, Mr. Tenen lived at the Potomac address, and then like we talked about, and I'll show you some documents in a minute, Mr. Ordway moved in and became the official tenant of the Potomac address, correct?
Yes, sir.
But January 5th of 2022, the year of the homicide, Mr. Tenen was in fact the tenant of Potomac.
Yes.
In this case, there was some FBI analysis done on cellular devices, correct?
That's correct.
Okay. And in this case, Agent Blythe, who I expect the jury will hear from during the course of this trial, he was not a detective in this case, correct?
No.
He was solely utilized by law enforcement to do cast analysis or cell phone analysis of location of devices, correct?
Yes.
He didn't subpoena any documents?
No.
You and your team took care of that?
Yes.
So whatever documents he used from T-Mobile or Google or whatever the case may be, that's information that your investigative team subpoenaed, gathered, got by way of warrant, however, and then you would provide that to Agent Blythe, correct?
Yes, sir.
If there was a particular address in this case, that's not something Agent Blythe would be aware of. He would rely on the investigators and the detectives, such as yourself, to give him that information, correct?
Correct.
So if there was a location of interest, not something Agent Blythe would have any idea about, he would rely on you to give him the information, and then he would map it, correct?
Yes, sir.
And I'll allow him and the government to go through all of his analysis, but in fact, he did mapping in this case.
Yes, sir.
And there are certain days of interest that the information you provided him, he mapped for you at your request, correct?
Yes.
All right. So let's start with January 5th, okay? On January 5th, yes, and this for the record is, I'm just going to go back. I'm sorry, Detective. Before we go into January 5th, I forgot a question that I need to ask you, okay? Can I just take you back to the interview of Mr. Fernandez?
Yes, sir.
All right. And I'm sorry to jump around. I made this mistake. Don't hold it against me, please. Do you recall in the interview that Mr. Fernandez kept saying, I don't know why he got out of the car?
Yes, sir.
And let's talk about those interviews again. It is not uncommon that in law enforcement, a person can give a detail during an interview where they shouldn't know that detail, correct? Let me ask a better question. Sometimes there are details about a crime scene that only people that were at the crime scene are aware of. Do you agree with that?
Yes.
Okay. And sometimes when people give interviews, they oust themselves by accident, revealing a detail that only somebody at the crime scene or law enforcement would know, correct?
That's correct.
Okay. And when Mr. Fernandez was interviewed, it was a couple weeks after the homicide?
Yes.
An important detail that this jury should know is that you had not released to the media that the tire was in the road. That was not public information.
I do know it was released eventually. I don't remember the exact timeline that it was released.
Okay. I'm not concerned about when it was released.
Okay.
What I'm concerned about is that at the time Mr. Fernandez was interviewed, you know that it had not been released at that point.
Correct.
That's what I'm asking you. So when he's saying, I don't know why he would get out of the car, he doesn't know that there was a tire in the road, correct?
I don't know I can't testify to what he knows or doesn't know.
He doesn't say anything about a tire, correct?
Not during the interview, no.
Right. He says something about maybe he knew the person in front of him, or maybe I just can't imagine why he didn't run him over. He gives all sorts of, hypotheticals as to what happened, but he never mentions that there's a blockade or a tire or anything obstructing the roadway. Never even suggests that at all, correct?
That's correct.
Okay. And I'm so sorry. I meant to ask you that question, and I forgot. May I have a moment, Your Honor?
Yes. Mr. Dreiser, can we take a break shortly?
It was public knowledge that Mr. Bridegan was killed outside of his vehicle, correct? That had been released.
I don't dispute that. I just don't know exactly what was and wasn't released.
To ask it real simple, there's not a single fact that Mr. Fernandez said to you regarding his hypotheticals of what could have happened that gave you any concern that he had more information than he should about the crime that occurred.
At the time of the interview, no.
Right. You assisted providing information to the FBI so that they could map slides, correct?
Yes, sir.
Some of the things that you would give were phone numbers, like Mr. Fernandez's, correct?
Correct.
To the FBI. So let's look at the top of, and can you see what's been marked and entered into evidence as State's Exhibit 182?
Yes.
And 182 is a composite of all of the work that the FBI, Agent Blythe, did in this work?
That's correct.
In this case, excuse me, right?
I think it's a slide as part of his overall deck, yes.
Yes. There's a deck of slides. That's the work that Agent Blythe completed in this case.
Correct.
I'm now showing you one of those slides.
Yes.
They're all in evidence, right?
Yes.
Okay. And at the top right corner, it says page 8. So that's an easy way to identify what slide we're looking at, right?
Yes, sir.
Okay. And then at the top, it says 904-566-2633. That was Mario Fernandez's phone number at the time, correct?
Yes.
And then this is January 5th of 2022, so the month preceding the homicide. And it's between 10:56 and 11:51. That's what the slide is suggesting the data shows on page 8 of State's Exhibit 182. Is that fair?
Yes.
And that's information, once again, that you provided the FBI so they could make these for us.
That's correct.
All right? So, in fact, in the legend, in the top right corner, it shows, and just, I don't know if the state asked you this, in your homicide training that you said you had, and you said admittedly it was mostly after the homicide, but you do have some CAS training.
I took like an introductory CAS course, yes.
Okay, and these are CAS slides, so you have some familiarity with what we're talking about.
Some, yes.
Okay, and I'm not going to ask you your opinion as to how these slides were made. We all can agree that is what Agent Blythe did in this case, not you.
That's correct.
But in the top right-hand corner, that is, again, where you were involved because you gave the information. And there's a little yellow, I don't know what you call it, marking, and you have the location of interest. See
Yes,
that?
sir. Yes.
And that's the Pablo Hamlet area.
That's correct.
And the jury heard a lot about Pablo Hamlet yesterday. That's the area where the Pablo Hamlet retirement community is and those other apartment complexes where the truck was seen a few times before and after the homicide.
Yes, sir.
Okay. And then you have the Fernandez residence, and that's in the legend in the top right-hand corner, right?
Yes, sir.
And 1511 Marshall is the Fernandez residence, right?
That's correct.
Okay. Fair to say that in this slide, it's just showing that Mario Fernandez was in the area of Jack's Beach at that time.
I'll let Agent Blythe speak to the slides, to interpret the slides.
Okay, so you don't feel comfortable, even with your limited knowledge and this being an evidence saying, yeah, it's Mario Fernandez's phone number and he's in Jack's Beach. You can't determine that?
I'm not saying I can't determine it. I'm saying Agent Blythe is an expert in this. He created these slides. I'll let him speak to them.
Well, I'm asking you to speak to it. So can you tell us, as the lead detective in this case, who furnished all of the information to make these slides, that Mario Fernandez, according to this slide, is in the area of his home between 10:56 and 11:51?
Yes, it would seem that he's utilizing, during the phone calls that are made on the slide, he's utilizing the green dotted cell towers.
And those cell towers are in the area of his home?
Yes.
You don't know where he is in Jack's Beach, you just know he's home.
I can only tell you what
Sorry,
the slide
you just
says.
know he's in the area of his home.
I can tell you that his cellular device is utilizing the towers that are indicated on the slide.
Okay. You could go to the next slide. On the other hand, you also provided the FBI so they could make maps. Henry Tennant's information, correct?
That's correct.
And then they were able to use geolocation to determine where Henry Tennant's devices went during the course of your investigation, correct?
Yes, sir.
And January 5th is one of the days in which you anticipate that Agent Blythe is going to testify about because you provided him information on those days, correct?
Yes, sir.
So without going into what the evidence shows specifically, you agree that on January 5th, not early in the afternoon in the first slide I showed you, later in the afternoon, Mr. Tennant's devices appear to travel from the Potomac address to Jack's Beach.
Yes, sir.
That you're comfortable saying?
Yes.
Okay. On this particular slide, page 9, you've added the crime scene, right?
Yes, sir.
You have no information that Henry Tennant's device went to the crime scene on January 5th, correct?
Based upon the slide and the data points that are here, it doesn't show that.
Okay, can you go to the next slide, please? I'm sorry, the next page number. This is a more zoomed in location of where the Fernandez residence, the location of interest is, correct?
Yes, sir.
All of this is Henry Tennant's device, correct?
That's correct.
Looking at page 9 or 10, you have no information as to where Mario Fernandez is on January 5th.
Not on the slide, no.
Okay. And I'll give you an opportunity to look at all of the slides from January 5th. But in all of the information that you provided the FBI on January 5th, you have no information as to where Mario Fernandez is on that date, correct?
There are no data points available, correct?
There are no data points available, therefore, you don't know where Mario Fernandez was on January 5th, correct?
There is no physical evidence to say where he was at.
Okay. Do you agree that's the same thing as saying you don't know where he was at?
Correct.
Could be at his house?
Correct.
Could be anywhere else, you have no idea.
Correct.
All right. So now, on January 5th, Henry Tennant's device does travel into the area of the Fernandez residence and the Pablo Hamlet residence, correct?
It travels to the data points that are here, which is, looks like down 15th onto Marsh Inlet and then down to the Cradle Creek area and then a little bit down Fairway.
Okay. Because of what you said about your comfortability, I'll save my cross-examination for Agent Blythe as to where exactly it went. But in this slide, no information about Mario Fernandez.
That's correct.
Okay. And I'm sorry, I'm going to stop saying slide. Page 10, can you go to page 11? This is more time period.
Yes,
Mr. Tennant's devices, correct?
that's correct.
No idea where Mr. Fernandez is or his devices are.
There's no information on the slide now.
So you did not provide that to the FBI, and you don't know.
Correct.
Next page. More zoomed in. Evidence that Mr. Tennant's devices were in the area of Jack's Beach on January 5th, right?
That's correct.
No information as to where Mr. Fernandez is that day.
No.
There's not a single piece of information that you can provide this jury on January 5th that you know that Mario Fernandez was with Mr. Tennant.
There's no physical evidence available for that now.
There is no evidence of that.
Correct.
And on January 5th, Henry Tennant was still the tenant of Mr. Fernandez, correct?
Yes.
So if the argument were to be made that he has no reason to be in that area, his landlord lives in that area, correct?
That's correct.
It's the 5th of the month, correct?
Correct.
It's the last month that Mr. Tennant was a tenant of Mr. Fernandez, correct?
I believe there's some information. I don't remember he was the end of December when he stopped being his tenant, or was it the beginning of January?
So you don't know as you're the lead. I mean, I'm asking you. Jeremy Ordway became the tenant of Potomac come February 1st, correct?
Yes.
Okay. So it's the last month that Henry Tennant was at the home prior to Jeremy Ordway, correct?
That's correct. I mean, I don't know exactly when Mr. Tennant's lease ended, is what I'm saying.
Understood. You did learn during this investigation that Mr. Tennant was having a hard time keeping up with his rent, correct?
Yes.
Okay. And that Mr. Fernandez was trying to work with him the best that he could, correct?
I believe there was some conversations that he was trying to work with him, yes.
And he was trying to get whatever money he could until he just could no longer keep him there because he just couldn't keep up with his rent payments, correct?
I assumed that that was the case, but I mean, I don't know exactly when the lease ended, is what I'm saying.
I gave you that. We don't know exactly when it ended. We just know when the new one started. But at this point in time, it's January 5th, and a person who, at that time or just prior to, who you just told the jury was having a hard time keeping up with his rent, is briefly in the area of his landlord's house for about 30 seconds on January 5th, correct?
That's correct.
And that's all the information that you have.
Based on this, yes.
Okay. I'm going to show you what's been marked and put into evidence as Defense Exhibit 19. Can you make that bigger? Okay, scroll down a little bit. All right. I'll zoom in. You and I may be more familiar than the jury with the evidence. You've seen this before?
Yes.
Okay. And this is a rental agreement between Jerry Ordway and Jeremy Ordway for the Potomac address, correct?
Yes.
And this is the and it's signed, if you scroll to the bottom. It's signed by Mr. Fernandez, correct?
That's correct.
And it's signed by Jerry Ordway and Jeremy Ordway?
Correct.
And it's 1/27/22, right before the 1st of February.
Yes, sir.
And you were able to find that lease at Potomac when you guys did the search at Potomac?
Yes, sir, that's correct.
And you were able to confirm with Jeremy Ordway that he lived there and he was the tenant.
That's correct.
Okay, so that all adds up.
Yes.
And through your investigation, you learned that Jeremy Ordway did in fact pay rent to Mr. Fernandez.
Yes.
You saw checks where Jeremy Ordway wrote his rent payment to Mr. Fernandez.
Yes.
You confirmed that people that would live at Potomac would also do some work to improve the property, and sometimes that would subsidize their rent, correct?
That's a vague question. I don't understand.
Okay. Mr. Ordway was confirmed that he did some work at Potomac while he was living there.
Yes.
Okay. You learned that Mr. Tenon did work at Potomac while he was living there.
It was stated that he did some work, yes.
No dispute that Jeremy Ordway took over and continued to pay Mr. Fernandez for living at 5239 Potomac Avenue.
No.
We talked a little bit about Mr. Tenon and his financial situation around the time of the homicide. I think you said he was having trouble keeping up with the rent.
I think you said that, but
And you agreed.
yes.
Okay. And he was not in a good financial situation at that time of his life, correct?
That's correct.
And you know that because you've seen his bank accounts and they don't have a ton of money in them, right?
That's correct.
And you know that because you have pawn records that you found where at that time Mr. Tenon was pawning things, correct?
I don't think I ever saw pawn records.
Okay, let me show you. What's been marked as Defense Exhibit 21, an Advance America pawn receipt from 2/26/2022. Oh, I'm sorry. I said the wrong thing. Pawn receipts. Advance America is he went on 2/26/2022 in Defense Exhibit 21, and he got a
Cash advance.
cash advance.
Yes, sir.
Okay. So approximately 15 days or so after the homicide, Mr. Tenon went and got a cash advance.
That's correct.
And as a detective, that would tell you that he needed money, correct?
That's correct.
Let's talk a little bit about John Biggerstaff, okay?
Okay.
John Biggerstaff is a longtime friend of Mr. Fernandez, correct?
That's correct.
John Biggerstaff's daughter went to high school with Mr. Fernandez, correct?
Yes.
And that's how he met John Biggerstaff decades ago, correct?
As I assume, or what I've heard, yes.
No reason to dispute that fact, right?
No.
Okay. And over the years, Mr. Fernandez and Mr. Biggerstaff did work together, correct?
Yes.
Mr. Biggerstaff had a little side business called 904 Handyman,
Yes.
and Mr. Fernandez had rental properties, correct?
Yes.
And there's no dispute, because I'm going to show you what's been marked into evidence here in a little bit, that you know that John Biggerstaff went to Potomac and did work. He did tile work there, correct?
Yes.
And you know that because you saw messages between them about doing tile work, and then we'll get into poll camera footage. You actually saw him show up and do the tile work.
Right.
All right. So no dispute that John Biggerstaff did work for Mario Fernandez.
No.
You also know that Mario Fernandez would hang out with John Biggerstaff from time to time, correct?
Yes.
They certainly weren't best friends, but they'd have a beer together every once in a while, right?
That's correct.
You also know in this case that John Biggerstaff's son, Juan Biggerstaff, around the time of the homicide, was getting married here in town, correct?
Yes.
And you know that Mr. Fernandez helped set up tables and chairs by using his pickup truck and delivered it to the wedding venue, correct?
That's correct.
You were able to confirm that with receipts from the table and rental company, right?
Yes, sir.
You were able to confirm that with some cellular data that Mr. Fernandez went after the homicide to a storage unit, and you were able to confirm that by people who saw him drop off tables and chairs.
That's correct.
Okay. So no dispute that they knew each other and they did things for one another like delivering tables and chairs, right?
Correct.
Like tile work, correct?
Correct.
On January 25th, you have reason to believe with cell phone data, and I'll save it all for Agent Blythe, that Mr. Fernandez went over to Mr. Biggerstaff's house on that date, correct?
That's correct.
You know, because we just talked about all the things, that that's not unusual that Mr. Fernandez would go to Mr. Biggerstaff's house, correct?
I mean, I have a limited period of time that we reviewed, but it didn't seem unusual.
Right, didn't seem unusual. And while he was there, you have no idea what he was doing at John Biggerstaff's house, correct?
That's correct.
You don't know if they were having beers. You don't know if they were involved. And let's just get it out in the open. Mr. Biggerstaff was a swinger, correct?
Yes, sir.
And his wife was a swinger, correct?
I never spoke to his wife about it.
Sure enough, okay. But Mr. Biggerstaff wanted to film people having sex with his wife, correct? They were into that.
I don't know.
You don't know?
I know on one occasion he did film his wife having sex, but I don't know. I can't say what he was into specifically
Are you sure it was only one occasion, Detective?
that I'm aware of.
Would you like to see, not the video, I don't think that's necessarily important, that on other dates, there are other men, not Mr. Fernandez, who had sexual relationships with Mr. Biggerstaff's wife. You dispute that?
No.
Okay. And you don't dispute that Mr. Biggerstaff participated in that, correct?
No.
It wasn't that Ms. Biggerstaff was cheating on Mr. Biggerstaff. That was a lifestyle that they chose to live, correct?
According to Mr. Biggerstaff, that's correct.
And the videos that will spare the jury from watching that we found in this case and we saw with our own eyes, correct?
That's correct.
Because you got Mr. Biggerstaff's cell phone downloads, and when you got them, you saw the videos, right?
I did not personally go through every single video, but there were a lot of explicit videos on his phone.
You're not disputing what I'm saying to you, are you?
I'm not.
Okay, so just so we're clear, I'm not making this up. This is what was on the phone, right?
That's correct.
And on that particular day, the day I've been asking you about, January 25th, you've already told me you don't know what Mr. Fernandez was doing over at that house, correct?
That's correct.
Other times, you had seen a video where Mr. Fernandez did have sex with John Biggerstaff's wife, correct?
That's correct.
But on that day, there is no video, but you just don't know, right?
Correct.
Beers in the garage, sex with his wife, helping him build a tool bench in his garage, or the tens of thousands of other things they could be doing together. You just don't know, correct?
I don't know.
But what you certainly have no evidence of is that Mr. Biggerstaff gave Mr. Fernandez a 10-millimeter firearm, do you?
There is no physical evidence of that now.
Okay. When you say no physical evidence, there is no evidence of that, correct?
There is no physical evidence of that.
Okay. So let's talk about John Biggerstaff and this 10-millimeter. Yesterday, I thought I heard you say that it was a very rare weapon. Is that what I heard you say?
Yes, sir.
You also told me in one time that we've previously spoke that it was no golden goose.
That's correct.
Okay. You also said yesterday it's no unicorn.
That's correct.
There are tens of thousands of 10-millimeter firearms out in the universe, correct?
It's probably accurate. I don't know exactly how many have been manufactured.
And let's talk about John Biggerstaff's first, and then let's talk about what your investigation revealed as to other 10-millimeters, all right? Back in 2016, John Biggerstaff bought a 10-millimeter firearm, correct?
That's correct.
All right. So just a little time perspective here. The homicide's in 2022.
Correct.
We're going all the way back to 2016, right?
Right.
I'm going to show you what's been marked in evidence as State's Exhibit 191. Can you publish? All right. Can you see that?
Yes, sir.
And this is a firearms tracing document that the ATF did in the assistance of this case, correct?
Yes, sir.
And this is how we know that John Biggerstaff owned a 10 millimeter back in 2016, because he bought one, right?
Yes, sir.
He bought it legally, right?
Yes, sir.
There's paperwork on it, right?
Yes.
And we know that he had a Glock 40 Gen 4. That's the manufacturer and the model. That's in the top right-hand corner, correct?
That's correct.
And we also know that the serial number of that firearm is BBG L770, correct?
Yes, sir.
So that's the basis of how we all know that 6 years prior to the homicide, John Biggerstaff owned a 10 millimeter, right?
Yes, sir.
So then you know that John Biggerstaff got himself in trouble right around the same time that he bought that gun, correct?
Correct.
He got arrested federally after the purchase of that gun in 2016, correct?
Yes.
And as a part of his arrest, a federal magistrate ordered Mr. Biggerstaff to forfeit and remove from his possession all of his firearms, correct?
Yes.
I'm going to show you what's been marked as Defense Exhibit 5. Okay. Can you see Defense Exhibit 5 on the screen, Detective Johns?
Yes, sir.
This is, in fact, an order setting conditions of release.
That's correct.
You go all the way to the bottom. While I'm scrolling down, you can see refrain from possessing a firearm, destructive device, or other dangerous weapons. Defendant shall immediately remove all firearms he currently owns from the residence, correct?
Correct.
And this was signed by a federal magistrate here in the Middle District in a building about a block from where we are right now, Monty Richardson, correct?
Correct.
You agree with me that federal magistrates take their orders pretty seriously, correct?
Yes.
And they ordered him, as I just read to you, to get rid of all of his firearms, correct?
That's correct.
So in order for him to do that, you would agree they just don't take your word for it. They make you fill out a firearms affidavit where you mark all of your firearms, their serial numbers, their information, so that you show and prove that you no longer have them in your possession, correct?
That's correct.
All right. So now I'm going to show you what's been marked, and that was signed, for the record, October 28th of 2016.
Correct.
And he hadn't been convicted of a felony at this point. This is just when he got arrested. This was his conditions of release order.
Correct.
Just make sure that's clear. Okay. This document's a little harder to see. Blow it up. You know, State's Exhibit 190 is, in fact, the federal firearms affidavit that John Biggerstaff filled out in 2016, correct?
I believe this list was completed by his son, but yes.
Right, because, of course, he can't be in possession of firearms once Magistrate Richardson says you can't be around your firearms. So by the very nature of filling out a firearms affidavit, you have to have some help, right?
Yes.
Because if you sat there and did it yourself, you'd immediately be in violation of the order, right?
That's correct.
And you came to learn that law enforcement was present when they did this, someone from federal probation.
I believe so. I don't know that for sure, but
Of course, you weren't there, but that's what you learned, is that his son, Juan Biggerstaff, was there with someone from federal probation.
That's what was told to us, yes.
Okay. And he had he had 20 firearms, right?
Yes.
So let's just be clear what this shows and what it doesn't show. We know he bought a 10-millimeter firearm in 2016, previous to this federal firearms affidavit being filled out. Do you agree with that?
Yes.
So if we are trying to look to see if we had a unaccounted for weapon, this would be a good spot to find out, right? Let me ask a better question. We got to look to see if a known firearm that we know he owned is included on this federal firearms affidavit. That's an important detail, correct?
Yes.
Okay, so let's zoom in to line 7. Do you see line 7?
Yes, I do.
And you've seen this document before. This isn't
Yes.
the first time. It says Glock, right?
Correct.
It says 40 Gen 4, correct?
Correct.
So just let's go back in time, just one exhibit before. It was a Glock, right?
That's correct.
It was a 40 Gen 4, correct?
That's right.
And then I read to you the serial number, and I read to you BBGL 773, I believe.
That's correct.
0, excuse me. The exact same firearm that Mr. Biggerstaff purchased in 2016 is documented as forfeited on his firearms affidavit, correct?
That's correct.
Later, in 2017, John Biggerstaff was in fact convicted of a felony, correct?
Yes.
John Biggerstaff, since 2017, has been and is a convicted felon, correct?
Correct.
A convicted felon under federal law cannot own or possess a firearm, correct?
That's correct.
Cannot own or possess ammunition, correct?
That's correct.
Under Florida state law, a convicted felon cannot own a firearm, correct?
That's correct.
They cannot own or possess any ammunition, correct?
Correct.
Okay. If you do, felonies, correct?
That's correct.
All right. You have no information that since 2016 that John Biggerstaff has ever been in possession of a firearm, correct?
I don't know that that's necessarily true. There's some information that he might have taken back his weapons.
Do you have any pictures of John Biggerstaff with his firearms?
No.
Do you have any surveillance of John Biggerstaff with any of his firearms?
No, I do not.
Has John Biggerstaff ever been arrested for felon in possession of a firearm since he's been a convicted felon?
No, sir.
In federal court?
No.
In state court?
No.
The firearm in this case, and the jury will hear all about, and they're going to hear from John Biggerstaff, and they're going to hear the trajectory of that firearm. But I'm asking you, during the course of your investigation, you didn't find a 10-millimeter firearm?
No, sir, we did not.
Okay. You interviewed John Biggerstaff to find out if he could tell you where that 10-millimeter firearm is, correct?
That's correct.
And to this day, there is no murder weapon in this case.
It has never been recovered.
So all these shell casings and all these projectiles and all the things that are sitting right here in front of the jury have never been matched to a particular firearm.
That's correct.
And to be very clear, they have not been matched to a Glock Gen 4 with the serial number BBGL770.
That's correct.
There has not been one single person to report to you that John Biggerstaff has had his firearms since 2017.
No, no one has directly said that.
And you've interviewed as many people as you could to try to get someone to tell you that, correct?
Yes?
There's no social media posts where John Biggerstaff is seen with a firearm, correct?
That's correct.
Now let's talk more generally about these 10-millimeter not unicorns, not golden goose weapons, okay? You did try in an investigative effort to see what you could find in Jacksonville regarding 10mm weapons, correct?
Yes, sir.
And about a month after the homicide, for whatever reason, you chose to go, or you and your investigative team, to Beach's Pawn. You know what I'm talking about?
Yes, sir.
That's just one pawn shop out of, I don't know, probably 100 or more pawn shops in town.
Yes, sir.
Okay. Just one that you picked?
We just, it's happened to be the only licensed firearms dealer in our jurisdiction. Due to the nature of pawn shops, we have a relationship with the owner. So we went to the pawn shop in Jax Beach that we knew that we could go to the owner and ask for his assistance.
And he assisted you?
Yes, he did.
Okay. I'm going to show you what's been marked and put into evidence as Defense Exhibit 55. I don't think it matters to show one for the moment. Okay. When you went to the pawn shop, you were able to get some paperwork regarding 10mm firearms that were sold by Beach's Pawn, correct?
That's correct.
And at the only pawn shop that you went to, in your jurisdiction, 6 10mm firearms had been sold when you went on March 15th of 2022. That's the evidence that you were provided, correct?
Yes, sir.
Okay. And out of the 6 transactions that are in evidence, every single one of them, and do you see the blacked out portions, Detective Johns?
Yes, sir.
I'm going to represent to you that we redacted their names. And do you agree that's just where someone who purchased a 10mm did so at Beach's Pawn?
Yes, sir.
And do you agree just to protect their privacy, that's why we did that?
That's correct.
There's no other information on that sheet that gives you any more information other than, in this particular case, a Glock 40 10mm firearm, correct?
Correct.
And I'll show all of them to you if you need to, but would you agree with me that out of the 6 that were sold from Beach's Pawn, 3, 50%, were Glock 10mm firearms?
Correct.
The exact model and the exact caliber, thank you, of firearm that you were looking for.
Yes.
Okay. And you didn't interview any of those 6 people, correct?
No, we did not.
You just looked and you saw whether or not they were associated in any way with a blue 2-tone truck.
That's correct.
And if they weren't, you just scratched them off your list.
That's correct.
Mr. Fernandez isn't associated with a blue 2-tone truck, correct?
No.
Do you have any records from any of the dozens or maybe 100 other licensed firearms dealers in the greater Jacksonville area that I can show this jury of how many other 10mm were sold?
I don't have numbers of that, and we developed no leads from any of the ones that were looked at.
You only looked at 6.
Correct.
No leads because you didn't talk to anybody, right?
Right. No leads were developed from them.
All right, I'm moving on. Now I'm asking you about all the other places. You have no other paperwork for me to show you or for me to enter into evidence to say, yeah, they went to 20 other licensed firearms dealers. They got another 100 Glock 10s, and they did or did not speak to those people. That does not exist in this case.
No.
You didn't go anywhere else and specifically look to associate anybody connected with Henry Tenon or anybody else regarding a 10mm in this case.
No.
You do know that Henry Tenon, on 2/9 of 2022, this is just days before the homicide, he did pawn some stuff, right?
Right.
Again, proof that Henry Tenen didn't have any money.
That's correct.
He's pawning he's pawning items that he owns. He's getting cash advances, correct?
Correct.
But a clue could be that in Defense Exhibit 20, this is a value pawn receipt. Can you see that?
Yes, sir.
You agree with me it's a value pawn receipt?
Yes.
You agree with me that the date is 2/9/2022?
That's correct.
You agree that it's Henry Tenen in the left-hand corner?
Yes, sir.
Right? 8701 Old King Road, correct?
That's correct.
That's not the Potomac address.
No, it's not.
Did you ever go to Value Pawn and Jewelry, the very pawn store that you knew that Henry Tenen dealt with, to see if they had sold any 10mm firearms?
No, it did not.
May we approach without the court reporter, Your Honor?
Yes.
So, for a little context, I've been trying to go chronological. I asked you about January 5th, then I asked you some questions about January 25th. You recall that?
Yes, sir.
And just so the jury can understand what I'm doing and why I'm doing it, I'm not just picking random days, correct?
That's correct.
Those are days that you thought had evidentiary value, then you provided evidence to the FBI, and then they mapped those dates, correct?
Those were dates that we found from stuff of evidentiary value that was provided to the FBI.
Exactly what I said, right?
Basically.
And those are the dates that I've chronologically gone through, correct?
Yes, sir.
So far I haven't skipped anything.
That's correct.
The next date is January 29th,
That's correct.
right? So that's where we're at now. So January 29th was a Saturday, correct?
I don't remember exactly what day it was. What day of the week it was, I apologize.
Okay. Any reason to dispute that it was a Saturday?
No.
Certainly, as you sit here as the lead detective in this case, you don't think it was a Wednesday.
No.
You haven't correlated like January 29th was a Wednesday, the homicide was a Wednesday. You take my representation, it was a Saturday.
Yes.
Certainly the government, if they find out I'm wrong, they can jump up and correct me, right?
Correct.
All right. So on the 29th, and I'm not going to go through all the detail. I understand Agent Blythe will tell you, this jury, what all these slides mean, but you're familiar generally what happens on the 29th, correct?
Yes.
All right, so let's walk through what happens on the 29th. Mario Fernandez, through his cellular data and timing advance records, which I'm going to save all for Agent Blythe, a way of tracking people, correct?
Yes.
Mario Fernandez goes from his home in Jacks Beach on the 29th over to the Potomac residence, correct?
Yes.
Now, one of the things I've spoken to you before, and you made it pretty clear this morning on what you're comfortable doing and what you're not comfortable doing, is whether Mr. Fernandez and Mr. Tenen are actually there at the same time and get there and are together before Mr. Tenen leaves Potomac, that's something we should save for Agent Blythe, correct?
He would be better able to explain the records to you, yes.
I appreciate that. But generally speaking, you agree with me that the records show that on January 29th, Mario Fernandez went from Potomac and he went from Marsh Inlet in Jacks Beach and he drove to the rental property that he owns at Potomac.
According to the slide, he is at what looks like to be Potomac.
But you know that he got there by going from his house, correct?
Yes.
Okay. Now, generally speaking, we know on that day that, well, generally speaking, you're not tracking people, correct? T-Mobile doesn't have a chip inside of Mario, correct?
Not that I'm aware of.
They're tracking devices, correct?
That would be a better question for T-Mobile. I'm not sure what they do and don't track.
I wasn't asking what T-Mobile was tracking. You, giving information to the FBI, you're tracking. These slides are tracking devices, correct?
These slides are based off of records that we've received from T-Mobile.
From the device.
Some of them from the device related, some of them from correlating cell towers.
I'm really not trying to play gotcha detective. They take the information that the device has via timing advance records, via geolocation, whatever the case may be, and then it tells you where they believe that device to be, correct?
That's correct.
And if it's geolocation, it's more precise than, for example, timing advance records, correct?
Yes.
And I said, I'll let Agent Blythe go all into this, but just generally speaking, these maps are tracking where individual devices that are associated with known people go, right?
Yes.
That's as basic as I can say, and you'll agree, right?
Yes.
So on this day, when I say Mr. Fernandez went from his residence to Potomac, the information is that his cellular device went from that residence to Potomac, correct?
Correct.
All right. You've said in previous affidavits, and you know that studies through all of your training experience have shown, is that people are generally within arm's distance or a wingspan of their device in this modern era, correct?
Generally speaking, yes, that is true.
Right. So when I'm asking you questions about the 29th, I'm asking you questions about where an individual's device is, and then the jury can make a decision as to whether the person was there or not there, right?
Yes.
In this particular case, we know that around 2:02 in the afternoon on that Saturday of January 29th, 2022, Mr. Fernandez's device arrives at Potomac, correct?
According to the slide, yes.
Is there any other slide that you'd like to see that would give any other contrary information?
No.
And you, of course, have reviewed these slides before.
Yes.
At the top, 904-566-2633, that's Mr. Fernandez's device phone number, correct?
Yes.
And at 2:02, in the area of the Potomac residence is where his device is.
That's correct.
Now, that device stays at Potomac until approximately, we'll go to a slide where we can get exactly where it is. Just tell me approximately. So about 4:23, correct?
Yes.
Okay. You have no information that that device ever left Potomac between 2:02 and 4:23, correct?
Correct.
Let's talk about Henry Tennant's devices.
Okay.
Henry Tennant's devices around 2:02, and we're going to let Agent Blythe determine whether it's before that or after that, it leaves Potomac, correct?
Yes.
And Mr. Tennant's devices go all the way down to Nocatee in the area of where the victim lives, correct?
That's correct.
It drives around the gymnastics location where the children are, correct?
That's correct.
It then heads from that area over to the area of Sanctuary where this homicide occurred.
Correct.
Then it goes from the area where the homicide occurs back to Potomac, correct?
Yes.
In defense's opening statement, we told the jury that Henry Tennant murdered Jared Bridegan. Did you know that?
Only as of this morning.
Detective Johns, that evidence of what Mr. Tennant, the person who the defense is conceding is responsible for this homicide, went to an area where he otherwise doesn't normally go, correct?
That's correct.
That was evidence that suggested to you that that had something to do with this homicide, correct?
That's correct.
It then went to the actual homicide location, correct?
Yes, sir.
Henry Tenon was actually seen on video at the homicide location the night of the homicide, walking away from the homicide, correct?
That's correct.
So on the 29th, Henry Tenon's device, and by extension, the very concept that we just decided or agreed on earlier, is that most people are within arm's length of their device, correct?
Generally speaking, yes.
Okay. And that's why you believe Henry Tenon was with his device on that day, because he's with the device that goes to those locations, right?
Yes.
And then it leaves the homicide scene and it goes back to the Potomac area. No question, I think, in anyone's mind in this courtroom is that that had something to do with the eventual death and murder of Jared Bridegan, right?
Correct.
Okay. So now we know that Mr. Fernandez's device, and by extension of the studies, Mr. Fernandez's device is at Potomac. Mr. Tenon's device goes on this. If I called it a dry run, would you agree that that could be a proper term for this?
That was the term that was used, yes.
Okay. So I didn't make that up. The 29th, the dry run day, right?
Correct.
Okay. So now there are ways to determine if maybe someone isn't with their device, correct?
I'm not sure what you mean.
Okay. Let's say a device is pinging, or there are timing advance records that show a device is at Potomac.
Okay.
We'll use this very example that we're looking at right here. But then the surveillance would show that Mr. Fernandez is not at Potomac. That would be a way to determine if a person was not with their device, correct?
If we had surveillance, yes.
And that's my next question. You have no surveillance showing Mr. Fernandez with Mr. Tenon on that day, correct?
To be fair, we also have no surveillance of Mr. Tenon either.
Well, let's talk about what you do have. Because maybe someone could say, well, you don't have any surveillance of Mr. Tenon. You have license plate readers, right?
Yes, sir.
And you have license plate readers of Mr. Tenon's truck, correct?
That's correct.
So there was an independent way for law enforcement to go, we got Henry Tenon's devices traveling in this area that he shouldn't be on a location that's highly suspicious. And we have an actual picture of a truck registered to his father, his late father. That was independent evidence besides cell phone, correct?
Yes.
You don't have any independent evidence that Mr. Fernandez was with Mr. Tenon when Mr. Tenon did whatever he did on the 29th, correct?
That's correct.
You don't have a receipt where Mr. Fernandez purchased something outside the area of Potomac while his cell phone was at Potomac, correct?
Correct.
You said yesterday that dozens of swabs were taken of the inside of that blue truck, correct?
Yes.
The blue truck, by way of the license plate readers, is the vehicle that was used to go on that dry run, correct?
Correct.
There's not a single shred of evidence that puts Mr. Fernandez inside of that blue truck, correct?
There is no physical evidence that puts him inside the truck.
There's no DNA, right?
Correct.
There's no fingerprints, right?
Correct.
Mr. Fernandez at the time, from what we saw in the interview, he had long hair. It was up in like a man bun, correct?
From the time of the interview, correct.
At the time of the interview?
Yes.
2 weeks after the homicide.
Yes.
No way he could have grown that hair that quickly, right?
Probably not.
You're a detective. Use your detection skills. In 2 weeks before your interview, Mr. Fernandez had long hair, correct?
Yes.
Special vacuums were used to vacuum out the blue Ford F-150 to find hairs so they could test them, correct?
That's correct.
Not a single one of Mr. Fernandez's hairs were in that car, correct?
Correct.
Certainly there was no evidence that that Ford blue F-150 was cleaned. Like, after a crime, some people may wipe out a kitchen floor or a vehicle or a handgun or whatever the case may be. That car was in pretty rough condition, correct?
When it was found months later, yes, that's correct. True, it was.
Didn't look like it had been cleaned out.
No.
Let's look at evidence that we do have. We just spent some time talking about digital evidence that would show that Mario Fernandez was at Potomac from 2:02 to approximately 4:23. That's what we talked about, right?
Yes.
Now, we certainly can agree that Mr. Fernandez owned that property, correct?
Correct.
We certainly agree that's a place where it's not he has a connection, a very big connection to that property, right? It's not unusual that a landlord would go to a place that he owned, correct?
Not unusual, no.
Let's also kind of revisit some of the history that we know about this case. It's the 29th, so it's one of the last days of the month, right?
Yes.
And it's also 2 days after and approximately 1 day before the new tenant, Mr. Ordway, is moving in, correct?
I know he moved in sometime in the month. I don't know exactly when.
It's the end of the month, and it's right in the middle of a transition of tenants, correct?
Yes.
The one thing we know for sure is it's 2 days after that lease was signed.
Correct.
And you know that all of the stuff that Mr. Tennant had when he was living there was moved into the garage.
Yes.
Because when you searched it, all the stuff you found was in the garage, correct?
That's correct.
It's not a foreign concept that the landlord may have gone to make sure all the stuff was put where it was supposed to go, correct?
That's correct.
And of course, it's not normal that a person would leave and leave stuff there, except for in this scenario, as we talked about, Jeremy Ordway and Henry Tennant were close family friends.
That's correct.
Okay. What is a pole camera?
It is a camera that is put on top of a pole.
Pretty simple. And in this case, pole cameras are law enforcement tools.
Yes.
Okay. I'm sure it could be anybody, but when I say pole camera, I'm talking about the pole cameras that law enforcement use as an investigatory tool in the investigation of this homicide, correct?
Yes.
You guys put up pole cameras at Potomac.
Yes, that's correct.
You put up pole cameras at Marsh Inlet.
That's correct.
You put up a pole camera, where else was there a pole camera? I think in Orlando.
No.
There's another pole camera somewhere.
The one off of Beach Boulevard.
Okay. You guys put up a few pole cameras. I'm going to focus on Potomac for the moment, right?
Okay.
You didn't tell Mr. Fernandez that you put up a pole camera, correct?
Correct.
They're done as a way of trying to find evidence. You don't put anybody on notice that you're doing that, right?
That's correct.
And in this case, you put up a pole camera sometime in August of 2022.
Yes.
Detective Johns, I'm going to represent to you that the defense in Exhibit 33, okay? Let me show this to you. Yeah, approach that one. You said I can move around, right?
Sure.
I approach?
Yes. What exhibit is that?
I said 33, but it's 31.
Okay.
Mistake. Sorry. Detective Johns, can you see defense 31?
Yes.
And this looks like a big old multi-terabyte jump drive.
Yes.
And there's a plug that goes in the computer, and there's a plug in the back.
Yes.
Okay? I'm going to represent to you that all of the poll camera, for all of the months that it ran at every single location, is on this, and it's in evidence by the defense, okay?
Okay.
So when I say I'm showing you some clips here in the next few minutes, I want you to know that if there's anything else that you think that they need to see, it's in evidence. They can look at anything they want. Fair enough?
Yes.
And then just so everyone understands how we're looking at this, this is defense 32, 33, and 34. Looks like a little jump drive,
Yes.
a little mini one of the big guys.
Yes.
And this has a number of clips from when you put up the poll camera where you captured Mario Fernandez at Potomac. Oh, we're going to look at it, but you understand that that happened, correct?
Yes.
You know what I'm talking about, correct?
Yes.
So if we're trying to figure out if Mr. Fernandez
It's the
would
homicide,
ever go
correct?
to,
So
well, let me back
You
up.
don't know
There
what
is
Mr.
no
Fernandez
poll
was
camera.
doing because there's just no surveillance of it, right?
On January
correct.
29th.
So
Because that
one
precedes the
way
homicide,
in law
correct?
enforcement
Correct.
is we
So you don't know what Mr. Fernandez was doing because there's just no surveillance of it, right?
That's correct.
So one way in law enforcement is we look, I think you said yesterday there's victimology. Do you recall that?
Yes.
Victimology is looking sort of at the past to see if there's any connections, right?
Yes.
So one of the things that you said was, I'm looking to see if it's a random act of violence. I looked at the victimology to determine that it was or it wasn't, right?
Correct.
Well, in the same concept, in the same vein, if Mario Fernandez's device is at Potomac on the 29th, and we have to kind of determine, is that unusual? Is that common? When you put up that poll camera, that could help answer some of those questions, correct?
I don't understand.
Well, let's find out. Did Mr. Fernandez go to Potomac?
Yes, he did.
Okay, so let's look at Defense Exhibit 33. That's the little guy I showed you, right? Are you aware that Mr. Fernandez, when you put up the poll camera in August, in the first 30 days, there are 20 different times that Mr. Fernandez went to the Potomac address?
I'm not sure how many times he did or did not go.
Okay, when we see him on these videos, I assume you don't dispute the poll camera footage, do you?
No, I don't.
Okay. Now, one of the other questions is, why would Mr. Fernandez go to Potomac? So let me ask you some questions. Potomac had some disrepair, correct?
Yes.
Like we talked about earlier, you were able to confirm that Mr. Fernandez was engaged in working on especially those tile floors, correct?
He was making repairs to the home.
No question about that.
No.
His bank records reflect that that's the case, right?
Yes.
The poll cameras reflect that that's the case, correct?
Yes.
Messages between Mr. Biggerstaff and others confirm that that was the case?
Yes.
So what are we looking at here? Oh, I haven't published it yet. May I publish Defense Exhibit 33, and I'm starting with A, Your Honor.
Yes.
Can you see that, Detective?
Yes, sir, I can.
Okay, can you pause it, Ms. Day? All right. Is this the poll camera located at Potomac?
Yes.
And is that the driveway leading to Potomac?
Yes, it is.
And when I say Potomac, we're talking about the residence that Mr. Fernandez owned. I don't need to keep saying the address, right?
Correct.
What kind of car or truck did Mr. Fernandez own in 2022?
Toyota Tundra.
What color?
It was white.
What do you see in the bottom right corner?
White Toyota Tundra.
That's the driveway at Potomac?
Yes.
Whose red car is backed up?
Mr. Ordway's.
The tenant.
Yes.
What time is it?
It is 7:45 a.m.
Okay. A little early in the morning.
Yes.
You learned, and if you can't remember, it may refresh your recollection, that Mr. Fernandez would come sometimes early in the morning, and depending on what work he was doing, he may come back multiple times in one day, correct?
Yes.
not to bore everyone to tears, I'm going to scroll forward, okay?
Okay.
If at any time,
Mr.
I'm sorry. I don't want to do that. Let me start over. We're going to scroll forward a little bit, okay?
Okay.
If at any given time you think I'm scrolling forward and missing a fact that you think is important, will you agree to tell me so I can make sure the jury sees it?
Yes.
Any reason to dispute that that's Mario Fernandez?
No.
You could see that someone got out and walked into the residence, correct?
I mean, I didn't see that specifically, but I don't doubt that he was there.
Can you look right? Oh, can you see right there?
Yes.
No reason to believe that's not Mr. Fernandez.
No.
Those were better views where you could really identify that was, in fact, Mr. Fernandez, correct?
Yes.
This is many months after the homicide, correct?
Yes.
Mr. Tennant has not been arrested yet, correct?
I don't believe so.
8/9/2022 to
No.
okay? But Mr. Fernandez is not distancing himself from the Potomac home as far as you can tell, right?
No.
This was after the tire was collected, correct?
Yes.
Jeremy Ordway's home, he knows that law enforcement came and collected that tire.
Yes.
You can kind of see his man bun there. Detective?
Yes.
I think it skipped or looped, but Mr. Fernandez left. The vehicle pulls out. You don't dispute that, right?
No.
Do you want to see it?
No.
Pulling out? He was there approximately 20 minutes or so, correct?
Correct.
Okay. And that was on 8/9/2022. I'm now going to show you another clip from the same day. Defense Exhibit 33B. Thank you, Ms. Stifler. I really appreciate that. Okay. So, is it published? Yes. All right. Same day, 8/9/2022, right?
Yes.
Same poll camera, correct?
Yes.
Same house, correct?
Yes.
2 p.m., 2:04 p.m., right?
Correct.
Mr. Ordway's vehicle still in the driveway.
Yes.
Pause. Okay. Mr. Fernandez's vehicle.
Yes.
This stuff, this time, it has boxes of construction materials in the back, correct?
There were boxes of something in the back.
Okay. Push by. let me say, the boxes are consistent with the work that you knew he was doing at Potomac, correct?
Most likely, yes.
Thank you. Scroll board. Okay, this time you can see Mr. Fernandez pulling out, correct?
Yes.
So he came back a second time in the day. Looks like 2 people got out of the vehicle. And all the stuff that was in the back of the vehicle is no longer in the vehicle when it pulls out.
That's correct.
Doesn't take a rocket science to determine that they dropped off what they had brought over.
Correct.
I'm now going to show you a video from August 16th. It's about a week later, correct?
Yes.
Defense Exhibit 33C, Your Honor.
Thank you.
Detective Johns, same house,
Yes.
same poll camera.
Yes.
It's 8/16/2022,
Yes.
and it's 6:43 p.m.
That's correct.
Jeremy Ordway's vehicle is in the driveway.
Yes.
There's a white Crown Vic in the driveway.
Yes.
Tell the jury whose white Crown Vic that is.
Mr. Ordway's father,
And who was known to drive that vehicle.
Mr. Tennant.
Mr. Tennant had not been arrested yet, correct?
Correct.
Stop. A week later, and Mr. Fernandez's vehicle pulls up, correct?
Yes.
You're not disputing that's Mr. Fernandez?
No.
You're not disputing that there's more materials in the back of the car?
No.
The bed of the truck, excuse me.
No.
Those are consistent with the same type of construction material? Well, I'm not going to say, we don't know. Same boxes that were dropped off and unloaded back on August 9th, correct?
Yes.
Pause it. There's a black dog. Do you see that?
Yes.
Tell the jury whose black dog that is.
It was Mr. Tennant's dog.
That's the same dog that when Mr. Tennant was arrested was with Mr. Tennant, correct?
That's correct.
It's the same dog that we heard from Detective Burrell when Mr. Tennant got out of his car. He put a dog bowl down. You weren't in here, but I'm sure you know that from Detective Burrell.
Yes.
It's because Mr. Tennant had a little black dog, or a medium-sized black dog.
Yes.
Okay? No dispute, Mr. Fernandez got out of his vehicle?
No.
That is Mr. Fernandez.
Yes.
appears Mr. Fernandez got a couple white bags out of the back of his cab,
Yes.
and he appears to be carrying those white bags into the Potomac rental property that he owns, correct?
Yes.
Go very slow. Okay, stop. All right, Detective Johns. That's Henry Tenen, correct?
Yes.
So on 8/16, some 6 months post the homicide, Henry Tenen comes out of the Potomac address home, and he's going to start unloading construction materials from Mr. Fernandez's truck and bringing him inside, correct?
Yes.
Mr. Fernandez is with Mr. Tenen. He hasn't distanced himself from Mr. Tenen, correct?
No.
They're on camera together.
Yes.
Mr. Tenen is doing something for Mr. Fernandez. I mean, he's laboring for him, correct?
Helping unload a truck at least.
You heard in phone calls and wire calls and Sonny Fong's call that Mr. Fernandez, according to Mr. Fernandez on the wire call, that he paid Mr. Tenen to do work for him, correct?
Yes, that's correct.
And then, of course, unbeknownst to what he said on a call, you have no reason to believe Mario Fernandez knew that his phone was being tapped on that T9 wire you talked about yesterday, correct?
I don't have any evidence that he knew.
And you have no evidence to believe he knew he was being recorded here, correct?
No.
Can you stop it? We have a new character I'd like you to introduce the jury to.
I believe that's Mr. Ordway.
And that's the dog jumping up on Mr. Ordway?
Yes.
So this is now some evidence that when we see his car there, it's not some kind of ruse. Mr. Ordway is there because you see him there on the poll camera.
Yes.
You learned through this investigation that Mr. Ordway was a pizza delivery man?
That's correct.
Okay, and he worked typically in the evening hours, correct?
That's correct.
And that's Mr. Tenen unloading those materials, whatever they may be, from the truck.
Yes.
Now, again, we don't know by looking at it, but you do know at this time, this is when the text messages are flying back and forth about the tile, correct?
What do you mean?
The tile floor that needed to be done at Potomac.
Yes, sorry.
And then another little clue that we could look at is in evidence, the state put photos of Potomac and it needed tile flooring. It was ripped up.
Yes.
So there's text messages about tile work that needs to be done at Potomac. The pictures confirm tile work needs to be done at Potomac. And then you have this construction material in and around the same weeks of time that these conversations are happening. It's not a leap of imagination that those could be tile. It would be consistent that tile would be being dropped off, right?
That's correct.
And I'm not going to jump the gun here. I know this is exciting, but we're going to see tile work being done at Potomac on the poll camera. We're going to see a wet saw, right?
Yes.
And you're going to see the water running down. That's going to tell us that they're doing tile work at Potomac, right?
I would assume so, yes.
All right. while we're watching this, for more context, this is 2 days before Henry Tennant gets arrested.
Yes.
And Mr. Tennant was arrested driving while license suspended or revoked. We heard that yesterday, right?
Yes.
And then there was some old shotgun that he wasn't charged with, but they ended up arresting him for, right?
That's correct.
And that was the white Crown Vic that he was pulled over in.
That's correct.
Mr. Fernandez leaves on that day. No dispute as to that.
No.
And the materials are gone.
Correct.
Now I'm going to show you Defense Exhibit 33D. This is August 17th, 2022. And that's 1 day later, correct?
Yes.
Not to be so redundant, but it's 7:48 in the morning, right?
Correct.
So we've seen him there in the evening hours, we've seen him there in the morning, and we've seen him there in the afternoon, correct?
That's correct.
It's Mr. Fernandez's truck, right?
Yes.
No dispute it's Mr. Fernandez,
No.
and no dispute that Jeremy Ordway's vehicle is parked in the driveway.
That's correct.
Okay? Now, on the 29th, you follow me? I don't want it to be too confusing. The day that Mr. Tennant does whatever he does on that dry run, that would be an example of when Mr. Fernandez could be at Potomac and there not being a tenant there, correct? Because if Mr. Fernandez is with his cell phone, and the jury will make that determination, and Mr. Tennant is with his cell phone, then possibly Mr. Fernandez would have been at Potomac without the tenant being there, right?
It is possible that Mr. Fernandez would be at a rental property without the tenant being there, yes.
Okay, but now I just want to show you that we don't have to guess whether it's a possibility, because we're going to see it. For the record, this is Defense Exhibit 33F, if I did not say so.
Thank you.
Did you go too fast? That appeared to be Mr. Ordway walking by his vehicle.
I can't really tell.
Okay. Skinny white guy matching the description of Jeremy Ordway.
Probably Mr. Ordway.
Looks like
It's probably Mr. Ordway.
And it looks like he was getting into the vehicle that you know Mr. Ordway to drive.
Yes, that's correct.
Okay, and at 8:09, 43 seconds, Mr. Ordway gets into his vehicle and he backs out and he drives away from the Potomac address. Is that a fair description of what you just saw?
Yes.
This would be an example of when Mr. Fernandez would be at the rental property while a tenant leaves and he remains, correct?
Yes.
Go forward. Okay. Stop. In the very first video I showed you, we knew that Mr. Fernandez went to the property. We knew he stayed about 20 minutes, and then he left. Fair to say, I couldn't tell you what he was doing there, right?
Correct.
You couldn't tell me what he was doing there, correct?
That's correct.
Seems consistent that he goes there to do work or arrange for work to be done, but we didn't know that, right?
I don't know why he was there.
Right. But in this video, who just pulled up?
Bueller Air Conditioning.
Okay. So does that give you a clue that maybe he was there to meet a vendor who's performing work on the property?
That's a fair statement.
And in fact, when you went through Mr. Fernandez's First Choice Home Rentals business account, at the same time that this was happening, there was receipts from Bueller Air Conditioning, correct?
Yes, that's correct.
And in fact, at some point prior to this, they had put in an entire new air conditioning unit at Potomac.
Yes.
And it was Bueller that put it in.
Yes.
So this all sort of makes sense, right?
Yes.
Here's that was the Bueller air conditioning man going in, coming out,
Yes.
doing work at the property.
Yes.
Here's Mr. Ordway, comes back to the property.
Yes.
Camera shows Bueller left,
Yes.
and shortly thereafter, Mr. Fernandez backs out and he leaves.
Yes.
Well, I guess he doesn't back out because he backed in, he pulls out.
Yes.
So in a situation where the jury may be left guessing what is going on the 29th, these, via poll camera, we can really deduce with evidence that Mr. Fernandez goes to his rental property for legitimate reasons, correct?
I can say that these show that he does go to the rental property for legitimate reasons, yes. I don't think it's a representation of necessarily what happens on the 29th.
I know you don't want to believe that. I'm asking what these videos show as compared to there not being video cameras on the 29th, correct?
Just clarifying my answer.
Okay. So if I were to make an argument, well, maybe he went to his rental property, we now know, and there is no dispute, that he goes to this rental property, right?
No, that's not in dispute.
He's not an absentee landlord, correct?
No.
Okay. So now let me show you another video from Defense Exhibit 33F. We just did that one? No, I don't think so. And if it wasn't clear, there were no cameras at Potomac on the 29th.
That's correct. There was not.
Now, pause it. This is another poll camera from 8/27/2022 at 6:08 p.m. Okay? Same poll camera,
Yes.
same address.
Yes.
What's important about this date is we can all agree Mr. Tenon has been arrested, correct?
Yes.
And you don't dispute that although Mr. Tenon was arrested for a driving offense, law enforcement went to Potomac that day and spoke to Jeremy Ordway, correct?
That's correct.
Detectives from the homicide unit, Detective Cullen and your partner, Detective Lamont, arrived and they told Jeremy Ordway that Henry Tenon was arrested in connection for the murder of Jared Bridegan, correct?
Yes.
Okay. So, Mr. Fernandez, he knows at this point that Henry Tenon had been arrested in connection to the murder of his wife's ex-husband, correct?
I would assume so, yes.
Right. We have to assume that. And I'm glad that you agree. And yet, even with that fact, Mr. Fernandez doesn't distance himself from the Potomac address, does he?
No.
No, because this is... All right, pause. Detective Johns, let's introduce a new character to the jury. Whose vehicle is that?
I'm actually not sure whose vehicle that is.
If I told you it was John Biggerstaff's vehicle, is that...
Oh, that's right. Yes, it is. I apologize.
Okay, so we don't disagree that's John Biggerstaff's vehicle, right?
Yes.
And again, you know, because of other investigative efforts, that John Biggerstaff was to perform tile work at the Potomac. We've talked about that.
Yes.
And now we see John Biggerstaff showing up at the Potomac address, right?
Yes.
And if I didn't ask you, early in the video, you saw Mr. Fernandez. This time he parked on the grass?
Yes.
Okay. So he's there as well?
Yes.
And just so there's no confusion, can you see the black dog?
Yes.
And you can see the Crown Vic, correct?
That's correct.
Can you pause it? Because this is important, but I want to make sure everyone understands the facts. Henry Tennant's in jail.
Yes.
They allowed him to park, instead of his vehicle being towed, someone took it and put it back at this address, right?
I believe Mr. Ordway came and got the vehicle.
Right. So just because we see the vehicle this particular time, we know Henry Tennant is not there.
That's correct.
And although we see his dog, we know he's not there because Mr. Ordway agreed to take custody and possession of Henry Tennant's dog after he got arrested, right?
That's correct.
Just another little piece of proof that they were friends, right?
Yes.
And Judge, if we could just get through this video, if that's a natural break for you. You told me at 2:15.
Yes, but before we do, I want to check in with you all for scheduling purposes.
Yes, ma'am. I was just giving you a heads up. I'm okay if you want to at the end of this video.
Okay, thanks.
All right. Before she puts play, can you see Mr. Fernandez?
Yes.
Okay. So we saw him pull up earlier, then we saw Mr. Biggerstaff pull in, and then it looks like Mr. Fernandez got out of his car to go meet Mr. Biggerstaff. We can deduce that?
Sure.
Okay, this is well after the homicide, correct?
Yes.
Some argument is to be made that John Biggerstaff actually gave Mr. Fernandez a 10-millimeter firearm to effectuate the murder of Jared Bridegan. If the government decides that they're going to make that argument, this video shows us that well after the homicide, Mr. Fernandez did not distance himself from Mr. Biggerstaff, correct?
That's correct.
Oh, the jury is watching this. Your Honor, I'm sorry, can I just have a few more minutes after this video?
Yes.
There's a connected video I'd like to show. Scroll. You can see that that is in fact Mr. Biggerstaff?
Yes.
Okay. Approximately 7:04 p.m., Mr. Biggerstaff's vehicle backs out and appears to leave.
Yes.
And then shortly after, Mr. Fernandez leaves, right?
Yes.
I want to show you Defense Exhibit 32B. This is the following evening. This is 8/28/2022. It's 9:18 p.m., correct?
Yes.
And this poll camera ran continuously, correct?
Yes, it did.
It wasn't motion activated. It caught everything that happened at that residence.
That's correct.
You can kind of scroll until Biggerstaff gets there. Okay. Pause it. Appears to be Mr. Biggerstaff is back, correct?
Yes.
You can scroll forward. Now, this video is about 3 hours and 20 minutes on 8/28/2022, right?
Yes.
You can see that by looking at the bottom.
Yes.
And this is the night that Mr. Biggerstaff goes over there and starts performing tile work, right?
Allegedly, yes. I mean, I can't see what he's doing, but
Well, we talked about
they
that.
spoke about doing tile work.
We talked about that wet saw, right? Right. Well, there's more videos, so let's break it down. You say you don't know what he was doing. Fair enough. I'll give you that. He meets up with. Okay, we can agree that you don't know what he was doing there that day.
No.
It's the day after he met Mr. Fernandez at the property, correct?
Yes.
They appeared to have a meeting in the driveway where they were talking, correct?
Yes.
The next day, Mr. Biggerstaff shows up, correct?
Yes.
Mr. Fernandez does not show up, correct?
That's correct.
So whatever Mr. Biggerstaff is doing at the Potomac address, he's not doing it with Mr. Fernandez, correct?
That's correct.
Yes. I'm going to now show you a video after midnight, the same time that he's there, Defense Exhibit 33G. Is that right? Can you see the bucket?
It's hard to make out what it is, honestly.
Trying to speed this along, but would you like to watch more to determine if you can see if that's a bucket and there's water all over the area where they're working?
It appears to be a bucket, and it appears that there's water on the ground.
Okay. And that would be consistent with the tile work that we talked about using a wet saw, right?
Yes.
Stop. Can you see Mr. Biggerstaff dumping the bucket now?
Yes.
You can see all the water coming out.
Yes.
A moment ago, you said, well, I don't know what he's doing there. Now we have some idea what he's doing there, right?
At least parts of it, he appears to be using a wet saw.
And he appears to be working, right?
Yes.
Good scroll. Now, at this point, you can see water that's now dripped all down the driveway, right?
Yes.
That was not there before, correct?
Correct.
And if we sat there and we watched this entire thing, you would see the progression of water from where Mr. Biggerstaff is working, pouring into the street, right?
Yes.
And then Mr. Biggerstaff leaves.
Yes.
You don't recall that John Biggerstaff was frustrated that Mr. Fernandez was making him do it on his time schedule, and that's not what they agreed on?
That's correct. Actually, yes.
Okay, that did refresh your recollection?
Yes.
Thank you for acknowledging that. So, as it turns out, around this time, Mr. Biggerstaff and Mr. Fernandez stopped communicating and doing work together. That's what you learned.
Correct.
And consistent with what you learned through looking at text messages and, you know, all those things that you were able to determine, interviewing John Biggerstaff, you then know that on the poll camera, Mr. Fernandez starts coming to finish the tile work, correct?
I know he starts coming to the house.
Let's see what we can determine from the poll camera, okay? This is now August 31st, 2022, 11:50. This is the Potomac address, black dog, and a Mr. Ordway's vehicle in the driveway, correct?
That's correct.
Here's Mr. Fernandez shows up this day.
Yes.
You can see Mr. Fernandez there.
Yes.
Mr. Fernandez appears to be standing in the back of the bed of the truck, and he's looking up at the roof.
I see him standing in the back of the truck. I don't know what he's doing.
All right. Stop. Does he appear to now be on top of the car, staring at the roof of the home?
He is on top of the car staring at something. I can't say what he is or isn't looking at.
Fair enough. If you were standing in front of Potomac, just because you've been there, correct?
Yes.
And the jury hasn't, you can see part of the house to the driveway to the right, correct? I mean, you can see the driveway to the right of Mr. Fernandez.
Yes.
In this particular setup, the house is on the side that Mr. Fernandez was looking at, not the other side of the driveway. And so the record's clear. The right side of the driveway, looking at this poll camera footage, has no house. The house is on the left side of the driveway, correct?
The driveway leads to the garage. The main structure of the home is on the left side.
So you understood my question and you agree with me?
Yes.
Thank you. Mr. Fernandez appears to leave the property, correct?
Yes.
Okay. I'm going to show you September 2nd, 2022. Defense Exhibit 33H. Let's move pretty quick. See the palette, right? We're close to that. No, that's September 4th. So the record's clear. This is September 2nd, 2022. This is 11:56 a.m. and Mr. Fernandez appears to be showing up at the rental property.
Yes.
You agree with that?
Yes.
And so far, everything I've showed you is within the first 30 days of you putting up this poll camera, correct?
Yes.
Well, 16 approximately, Mr. Fernandez appears to be leaving the rental property, correct?
Correct.
Okay, now I'm going to show you 33I. It's the same day, correct?
Yes.
The video I showed you before was a different time, but it was 9/2, September 2nd, 2022. This is a little bit later in the afternoon, correct?
Yes.
It shows Mr. Fernandez showing up again, correct?
Yes.
Without going into the specifics of some of those other days that I talked to you about, and some in which we haven't gotten to yet, January 5th, January 25th, January 29th, February 15th, February 16th, some of these important days that are days that you were investigating. We talked about that earlier, correct?
Yes.
One of the things that you know Agent Blythe is going to testify to is that on certain days you have Mr. Fernandez, by way of his cellular device, going to the Potomac address more than one time, correct?
Yes.
For example, on February 15th, he goes there in the morning, and then on February 15th, his cellular data shows that he goes back in the afternoon, correct?
I'm going to let Agent Blythe answer those questions. I don't know what he is or is not going to testify to.
Fair enough. I'll show you the slides from that day, and then you can tell me with your CAS training if it shows Mr. Fernandez going twice. And I think we've talked about it before, and you let me know, okay?
Okay.
Again, while Mr. Fernandez is there, Mr. Ordway's vehicle pulls out and leaves, correct?
That's correct.
Doesn't appear to have any other vehicles in the driveway besides Mr. Fernandez, correct?
That's correct.
Another example where Mr. Fernandez may be at the residence while the tenant is currently not there, correct?
Correct.
And in this daylight video, you can see that orange bucket in the near location by the door to the residence, correct?
Yes.
Go to the next one. And Mr. Fernandez's vehicle leaves, correct?
Yes.
Okay, I'm going to show you the next numbered 33I. It's the same day. It's at 8:31 p.m., correct?
Yes.
Okay. And again, Mr. Fernandez's vehicle shows up. Can you see the truck bed?
Yes, again.
Okay, go forward. Looks like Mr. Ordway's vehicle is there.
That's correct.
So your poll camera evidenced Mr. Fernandez going 3 times in one day on September 2nd, 2022, correct?
Yes.
Next, I'm going to show you 33L. This is now September 3rd, the next day at 1:55 p.m.
Yes.
Mr. Fernandez pulls up.
Yes.
You can see Mr. Fernandez there briefly.
Yes.
Nine three, Mr. Fernandez leaves, correct?
Yes.
I'm going to show you September 5th, 2022, 33M. 33M. Okay, I'm going to go back to 9/4, 33L. In this particular video, at 1:18, while Mr. Fernandez is there, you see a trailer pull up?
I see a trailer in the frame, yes.
And what's stacked in the back of that trailer?
Pallets?
Okay. And that was the business, although Mr. Tenon has been arrested, that's the business that Mr. Tenon was in, the pallet company, correct?
He worked at Monison Pallets.
Right? And through your investigative efforts and all the evidence that's been admitted by the state attorneys, Mr. Tenon was interested in starting a pallet business. You learned that, correct?
He did have some interest in starting a business, yes.
Okay. And then you were able to look through some of the paperwork that you found in his possession, correct?
Yes.
Okay. You found ledgers that indicated that he had detailed notes about costs and pallets and things of that nature?
I know he had the notebook that you're holding in your hand that had some figures in it.
Okay. That's one of the notebooks that had figures, but this, just for the record, where did I pull this out? It's from States 197. And I'm looking at a composition notebook.
Is that 197? Okay.
Okay, so some of the photos that aren't contained in this, that you referenced, which are other ledgers and things of that nature, are also contained in States Exhibit 197, okay?
Okay.
But I'm holding up what was also pulled as part of that composite of States 197, a blue composition notebook. And publish that. I'm showing you what's on approximately the third page of that States 197. Can you see that, Detective Johns?
Yes, sir.
It says business plan, right?
That's correct.
Name of business, colon, Tenon Pallet Recycling, period, correct?
Yes.
Location, colon, Drayton, Georgia, period, correct?
Yes.
Henry Tenon has connections to Georgia, correct?
Yes.
His family and his father live there.
That's correct.
Action number 1, collect pallets for repair to be sold, correct?
Yes.
Air compressor, nail guns, staple guns. Those are supplies.
I would assume.
Number 3, dismantling pallets for materials, period. You agree with that's what it says?
Yes.
Mr. Tenon didn't write that since he's been in jail. You know that, right?
Correct.
So that was written prior to him being arrested, and this was found at Potomac, correct?
Yes.
So we don't have to guess whether Mr. Tenon, at least in his mind, wanted to start a pallet company, correct?
According to his notes, it seemed like he did want to start a pallet company.
He had a name for the pallet company, right?
Yes.
He had it, albeit pretty simple, he had an action plan, right?
Yes.
Mr. Tenon wasn't an extremely educated person, was he?
I'm not sure of his education.
You're the lead detective in a homicide case where 3 people were arrested for a homicide. Any reason to believe Mr. Tenon had a college degree?
No.
Okay. He was a day laborer?
Yes.
Nonetheless, he had an action plan, he had supplies consistent with a business plan, and he had things that he wanted to do in order to effectuate a company with a name and a location. That we can determine from that composition book, correct?
He did have the notes in the composition book. I don't believe he had any supplies that I'm aware of.
He listed supplies.
Yes, he did.
I'll come back to that. I digress, but at 1:18, after he's arrested, on poll camera, a truck with pallets does arrive at the Potomac address.
There was a trailer with pallets in the frame.
Okay. Maybe it's not clear. Like I stopped it right when it was driving by. You want to see it so that you can see that it stopped there? So just back it up a little bit. Can you tell that I'm scrolling minutes and it's still there? You can, it's okay.
Looks frozen on my screen.
Maybe it is. Let me see. Can you tell it's not frozen now?
Yes.
Can you tell that's not moving?
Yes.
Definitely stops in front of Potomac
It would appear that's true, yes.
while Mr. Fernandez is there.
Yes.
Okay, go back. I think so. Faster. that orange bucket that we keep talking about? It was in the frame earlier, up in the top left corner, right?
Yes.
Now, you see Mr. Fernandez, he grabs the bucket, comes to the end of the driveway, and he dumps all the water, right?
Yes.
The same thing Mr. Biggerstaff did about the time he was leaving the Potomac address, correct?
Appears to be a similar action.
Right. Where do we leave off? Then pull forward. And again, around 1:46, Mr. Fernandez leaves the property, correct?
Yes.
Exhibit 33M. For the record, Defense Exhibit 33M, Your Honor.
Thank you.
This is 9/5/2022, the following day, correct, Detective?
Yes.
Mr. Fernandez shows up, right?
Yes.
You can see his truck.
Yes.
Roll. It's at the end. Just take your time. Be patient. I think it's frozen. Try. One more try. It's in evidence. On 9/5, he's there and he leaves again. Is that correct?
Yes.
The following day, September 6th, Defense Exhibit 33N. Mr. Fernandez shows up, Detective.
Yes.
That orange bucket you can see moving in the corner again.
I haven't seen it move.
Jury can determine, I suppose. Maybe let it catch up and then scroll again. I'm just show leaving for him. Nonetheless, he's there, he leaves, correct?
Yes, sir.
Defense Exhibit 33O. This is the same day, 9/6/2022, but it's later at night, correct?
Yes, sir.
Mr. Fernandez arrives.
Yes.
I know we're going fast, Detective, but in the upper left-hand corner, can you see the bucket moving back and forth? It appears that work is being done.
I did see it this time, yes.
Try and move it along. You can see the bucket come into frame. You can see it come out of frame.
Yes, sir.
All right, thank you. see Mr. Fernandez in the bottom right-hand corner with the bucket, and he's dumping it?
Yes, sir.
Okay. And this is about 2 minutes before he leaves the residence. Detective?
He hasn't left yet. I'm assuming
I guess if you look at the bottom right-hand corner, you can...
there's 2 minutes, 19 seconds left of the video.
All right, but in fairness, you don't know that I cut it where he leaves, so we can scroll to it. Understand. Okay, he's now gone at 11:22.
Yes.
So he stayed there, and it looked like he was performing work for a couple hours.
Yes.
September 8th, 2022, Exhibit 33P. This is now in the morning, Detective?
Yes, sir.
Mr. Fernandez appears, his truck gets there around 10:30-ish.
Yes.
That's all right. So easy to find last time. All right, there it is. See Mr. Fernandez again with the bucket coming out.
Yes, sir.
There seems to be a theme that Mr. Fernandez is going there and he's doing tile work, correct?
I can't say what he is or isn't doing inside the home. He is carrying a bucket over several repeated days in and out of the house and dumping some water.
Okay. We can't say, but with all the evidence that you have, it's not inconsistent with him finishing the tile work that John Biggerstaff was contracted to do, correct?
That's correct.
Move to Defense Exhibit 33Q. Timestamp is. All right, go back. In this video, is that Mr. Fernandez?
It appears to be him, yes.
Okay, it appears that he has a broom in his hand.
Yes.
He appears to be brushing the driveway.
That's correct.
You don't have to guess that he's doing some work at Potomac on this day. You can actually see it.
That's correct.
This looks like it's the lumber. Were you able to see that he left on that particular day?
Yes, sir.
All right, thank you, Detective Johns. Detective Johns, in evidence, if I represent to you that on September 11th, Mr. Fernandez goes back to Potomac, is seen on video, would you dispute that?
No.
If I told you on September 13th that he went back and he did that, would you dispute that?
No, sir.
I told you at the very onset of this exercise that in the very first 30 days that you put up a poll camera, Mr. Fernandez was at that home doing work 20 times. And did you see that when I showed it to you?
Yes.